All right, good morning, everyone. We are going to call to order the Judiciary Committee public hearing for Monday, March 10th. Couple quick ground rules out of courtesy to others who are behind you. We limit folks to a strict 3 minutes. The bell will go off, or if you're testifying remotely, we will interrupt you at 3 minutes and tell you it's time to take questions. I will make my daily admonishment like I will every day this session. Please do not come up here and read your testimony. We are all adults. We all can all read. We have your written testimony in front of us on our laptops. I will say that again. We have your written testimony in front of us on your laptops. So to come up here and read it to us really frankly does us no good. Come up, mention you've submitted written testimony, highlight a couple key points, maybe address some questions that have come up earlier in the day if you're so inclined, but we don't need you to speed read your testimony to us. All right. We will go in the order on our list here. We don't allow folks to trade spots. If you get skipped and time permits, we will try to get to you at the end of our day. But with that, let's jump in. First name I have is Jackie Gagne. Jackie Gagne with us? No? All right. Sohail Lakadawala?
Pronounced Lokhandwala. Thank you. Um, no worries, no worries. So to all, dear all members of the Joint Judiciary. Wait, can you hear? Can you guys hear me?
Yep, you're good. Go ahead.
Perfect. Thank you. So members of the Joint Judiciary Committee, thank you. My name is Sohail Lokhandwala. I'm a resident of South Windsor, Connecticut. I submitted some written testimony, and I'm testifying today in opposition to the Governor's Bill 6872, which is an act revising and consolidating the hate crime statutes. And some of the main points I submitted against it were the vague language, which could be used as a potential weapon against fair expressions of free speech. And obviously, I understand the necessity of stopping hate crimes, but this bill really, I think, only introduces punitive measures as a response, which is something that I just don't think will work. So one of the things I highlighted was that in lines 103 through 104, it criminalizes the urging and advocating of individuals that commit violence. And, I think this is just really not well defined and is really loose and up to interpretation. So, and I'll give you an example is I personally have been involved in many protests against the genocide of the Palestinian people, and I have seen a lot of bad faith actors intentionally misrepresent a lot of our chants to make them seem like they are advocating for violence when the reality is that they're actually just calling for an end to violence and legal occupation. One example of this is the chant "From the River to the Sea." That's something that is chanted a lot and has been sort of misrepresented. And I worry that with this legislation, it could, if it interprets chants like that as, hate speech, it could really shut down discussion. Additionally, this bill extends penalties on those who commit hate crimes while wearing masks, and we've seen a weaponization of anti-mask laws in other states like New York. And I really would question what the actual purpose of this is. Why additionally criminalize someone who is committing a hate crime while wearing a mask? And what I think that the main consequence of this would be is that it would scare peaceful protesters into not wearing masks at protests, which is something that they may be doing in order to protect themselves from doxing or from illness or from any other sort of or for whatever reason that they may want to. It's their right of freedom of speech. And I think I see this as the state sort of intimidating them into taking off their masks. So I think that this is a very dangerous measure in this bill. And I guess on a more broad note, I would say that these sort of overt and additional criminalization of certain actions is not going to be the real root solution to bigotry. And I think instead of focusing resources on these punitive measures, the state should emphasize more more sort of education and things that solve the underlying issues behind bigotry. So I'll be happy to take any questions.
Thank you. Questions from the committee? Other questions from the committee? If not, we appreciate your written testimony and for being with us this morning.
Thank you.
Jonathan Mann.
Hi. Hi, committee members. I did not submit my written testimony. I just wrote it, so I'll go on my rant. Hi, committee members. My name is Jonathan Mann. I live in Hartford with my wife and 3 kids. We're foster parents. I'm Jewish and a proud member of the Hartford Jewish Organizing Collective. I oppose 6872 because there is a nationwide full court press right now to straight up criminalize any and all criticisms of Israel. A bill like this one must make it absolutely crystal clear that criticizing Zionism, a political ideology, or Israel, a nation, is 1,000% not the same thing as committing the hate crime of anti-Semitism. And the stakes could actually not be higher on this point, because just yesterday, we saw the news that ICE agents had raided the campus home of a Palestinian Columbia University student. They threatened to arrest his wife, an American citizen who's 8 months pregnant. They told her they were taking him to a detention center in New Jersey, but when she went to visit him, he wasn't there. And as of now, they don't know where he's being held. And it feels to me like we're heading into some really dark territory with this stuff. And Jews have been here before, because the law they plan to use to revoke his green card and deport him was written specifically to do the exact same thing to Jews in the 1950s. And so I feel like if we don't speak up in support of students, even as they're labeled anti-Semitic terrorist supporters by the ADL, then we can't pretend that we would have spoken up for Jews being labeled as communist traitors back then. And so when it comes to anti-Semitism, it matters a lot which definition we use. The ADL's definition, for instance, includes anyone wearing a keffiyeh, anyone waving a Palestinian flag. It includes Palestinian students who were begging their universities to divest from the weapons manufacturers supplying the bombs that were being dropped on their families. And somehow the ADL's definition does not include the world's richest man literally hailing Hitler live on national television. And so I feel like the ADL kind of has their definition exactly backwards. Leading up to the election of Donald Trump, we listened as the governor and all Democrats warned about the coming authoritarian nightmare. And now that it's here, rather than fight with all our energy, strength, and power, as elected officials, Democrats seem hell-bent on helping Trump achieve his goals. And listen, like, I'm very active both online and locally with the movement for a free Palestine. And I do this not in spite of my Judaism, but because of it. So today it's a Palestinian graduate student. It's not hard to imagine getting to the point where the Trump administration labels all Palestinian supporters, Jewish or no, to be enemies of the state, worthy of detention or worse. And I don't think that's hyperbolic. I mean, this is Trump we are talking about. So the proposed edits to this bill, I feel like, will be used to target me and my friends as we exercise our right to protest for a free Palestine. The authors of this bill have got to go back and make it so my 7-year-old could read it and understand that an attack on a Jew for being Jewish, that is an anti-Semitic hate crime. Keffiyehs, flags, river to the sea, criticizing Zionism in Israel are not. Thank you. Sorry. Thanks.
Questions from the committee? Seeing none. Thanks for spending the morning with us. Catherine Bear.
Morning. Chairman Staff-Strom Winfield, ranking members Fishbein and Kissel, and members of the Judiciary Committee. My name is Catherine Bear. I'm an Executive Assistant State's Attorney at the Division of Criminal Justice, where I serve as Director of Policy Development. And I'm here today to speak on behalf of the division in support of HB 6872, an act revising and consolidating the hate crime statutes. This body and our state has done important work in recent years in the areas relating to hate crimes. In 2017, this legislature created the Hate Crimes Advisory Council, And in 2022, our state police created the specialized unit of the Hate Crimes Investigative Unit. Yet, ironically and technically speaking, we live in a state that doesn't have any crimes that are actually labeled hate crimes. Instead, what we have is a patchwork quilt comprised of more than 20 separate statutory sections spread out across multiple titles and chapters of the general statutes. And in those more than 20 sections, there lacks uniformity as to who is protected under each particular section, as well as conflicting and multiple intents. For example, in just 53A 181J alone, the intimidation based on bigotry or bias statute, it contains 3 different intent requirements: malicious, specific intent, and motivated in whole or substantial part. Complicating matters further, malicious and substantial are not defined in our statutes. And so what this causes in practice to our law enforcement community, and particularly our police partners and prosecutors across the state, is that we're scrambling to both locate and understand these laws. Training is likewise unnecessarily complicated and confusing because the statutes are complicated and confusing. Professor Wilson, who's one of the architects of this proposed piece of legislation, said it best. He said, hate crimes in Connecticut are really Part B crimes, and that's dead on, because for the most part, they're labeled as misdemeanors or lower level felonies, which it means that they're generally prosecuted in our Part B courts. This leaves a glaring gap with respect to our more serious felony offenses, our Class A and B felony crimes, and no mechanism to recognize the separate and distinct harm that hate crimes cause with the individual and the communities affected. Connecticut should be proud of the stance that it's taken against hate crimes laws. Some of our statutes date back to the 1880s, but there's been no serious look at the entire scheme to see if it makes sense for us as we move forward, makes sense in connection with the other groups that this entity has formed. So a comprehensive review and consolidation of our hate crime statutes into one chapter where they're actually called hate crimes, with the inclusion of a penalty enhancement, a meaningful penalty enhancement, particularly with respect to our Class A and B felonies, is long overdue. I thank the committee for their time and happy to answer any questions you may have.
Questions from committee? Rep. Fishman?
Thank you, Mr. Chairman. Good morning.
Good morning.
I take it that you reviewed the proposed legislation.
Yes, sir.
Okay. And I wanted to ask, I mean, understanding that, public policy wise, anybody that, in my mind, anybody that creates a bad act with the underlying action being someone's race, religion, we have said, and I agree, as a state is a hate crime, and it's something that it's more than just a crime, it's a hate crime, right? The introduction of this concept of a victim of domestic violence, I think, diminishes hate crimes. Can you just explain, hate crimes as we traditionally know them? Can you just explain why it's good public policy that we introduce this concept into hate crime?
So I think the reasoning behind it, and the professors, Pandya and Wilson, who will testify before this entity later this morning, might be better equipped to answer this question, is that some of our statutes include that as a classification. And so it's been included to try to represent as accurately as possible where that group has been included in some of our bias-driven statutes. But you're right, Representative Fishman, that it's not traditionally been a category. It is an area in some of our bias-related offenses. And so that's certainly a topic that this body needs to consider in terms of, to the extent that it's broadening that classification at all. That's really a policy choice for this legislature to make.
Well, I'm just asking you, your opinion. You've come to us, whole swath saying this is good. Why, in your mind? Because to my mind, it diminishes, the more we put on the plane with hate crime, right? The less we say that conducting a bad act based upon race or creed, by way of example, it becomes just a crime, right? So why is that good public policy?
That's a fair comment. And my only response is a design to protect those classes that have been traditionally disadvantaged, and our understanding of what that term might be may continue to broaden. But I certainly understand the representative's concern, and again, I think that's an issue that would need to be fleshed out a little bit more.
Okay, I mean, public policy wise, we dealt with, coercive control. You may have heard, was it 3 years ago, we dealt with coercive control. We said, withholding necessities of your domestic partner is a bad act and could, although it isn't written that way, be restrained. We're now saying that withholding necessities is domestic violence because it's in 46B1. And now it becomes a hate crime, but I'll go on. In section, you have the bill,
I do.
section 10. And this is new language. I was trying to wrestle with this expansion because it says a person is guilty of a hate crime by advocacy. So this is not the committer of the act. This is someone, a third party who allegedly impresses someone, not conspiracy, because this is a brand new crime, I guess. Hate crime by advocacy. Do you know of any scenarios where this has been sought to be prosecuted and was unable to under our current statutes?
I'm not aware, yeah, sir. And also, I believe that language comes exactly from some existing law, but I apologize, I just can't put my finger on the current statute.
I mean, I'll take your representation. Usually when that happens, we repeal the underlying and then we republish, and this indicates section 10 that it's new language.
So I think all the sections indicate new because they've been reorganized and relabeled in many instances to accommodate for the fact that our existing statutes cross so many different titles and chapters. So, for example, section 11, which is on that same page, the deprivation of civil rights, I believe that derives from the 46A existing statutes. The language is exactly from there. So I don't believe it's whole cloth new, but again, I would defer to the professors who could answer that question much better than I.
Okay. And then we heard the gentleman speaking before about the hate crime with a mask or hood. Are you aware of any scenario where that would, so the language specifically carves out a hate crime with a mask or hood? I don't know what that means, quite frankly. Hate crime with a mask or hood, does that mean that your face is obscured? Does that mean that you're wearing? It's unclear, but now we're saying that's a Class D felony. So one could, let's say, burn a cross on someone's lawn, bad thing, right? But if they have a hood or a mask on, it's a Class D felony, but if they don't, it's something lower.
So, sir, it is an existing Class D felony under our current law, 53-37A, entitled deprivation of a person's civil rights by person wearing mask or hood, and the use of the mask is limited both by intent. That our current law says any person who, with the intent to subject or cause to be subjected any other person to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of this state or of the United States on account of religion, national origin, alienage, color, race, sex, gender identity or expression, sexual orientation, blindness, or physical disability, violates the provisions of section 46A58 while wearing a mask, comma, hood or other device designed to conceal the identity of such person shall be guilty of a Class D felony.
Okay, I'm looking at section 14,
Yep.
which deals with different statutes, and then this is new language. It's underlined. And this talks about 5337A. And it says a person is guilty of a hate crime with a mask or hood if such person.
Mhm.
And this particular portion at the end says while wearing a mask or hood or other device designed to conceal the identity of the person. So you're saying that's just rejiggering?
Correct. It's essentially the identical language to our existing law. Yes.
So we're at the end of A, it says shall be guilty of. It's being separated out and the B is being added. Is that, am I reading that correctly?
I believe it's just to make the verb tenses work with, yes, the refiguring of the protected social category language.
Okay, I'm just trying to, along with the testimony of the gentleman before you, who is obviously adamant against the mask or hood aspect, just trying to put this together.
Absolutely. And the First Amendment concerns are valid. And that's something that our statutes have been careful to consider. And to the extent that they haven't been challenged, they may be subject to challenge. However, for the most part, our existing bias-driven statutes are aimed at conduct of individuals, not speech. The state is not looking to repress First Amendment rights of any of the people that we prosecute. It's the conduct that is the focus of our concern.
Well, I understand, but I can also understand the broad application of this language, because certainly 5337A deals with the deprivation of rights, privileges, or immunities. So if somebody is shouted down, there's ways to do that, I'm just trying to deal with all the scenarios. So, but thank you, Mr. Chairman.
Representative Howard.
Thank you, Mr. Chairman. Attorney Barrett, good morning.
Good morning.
Thank you for being here. I had a couple of brief questions, and one of them, I'm going to start in section 5 in line 125. I think it's a drafting error. I doubt it, the amount of attorneys that looked at this, because I'm just a policeman, but it seems to suggest that in line 25, an amount in excess of $1,000 is an E felony, but then it goes on, I'm sorry, is an A misdemeanor, but then it goes on to say an amount in excess of 1,000 is an E felony. It's confusing. I don't understand.
Thank you. I believe the judicial branch in their written testimony has highlighted, and this might be exactly one of those instances where if the amount is off with our current law or consistency, there may need to be some tweaks to make sure that that they are consistent and that the fine amount is where it needs to be relative to our existing law.
But this isn't fines. This is the corpus delicti of the crime, right?
Mhm. Yes.
So if I read it right, it says a violation of this section shall be a Class A misdemeanor for which the court shall impose a fine not less than 1,000 if the damage is as a consequence is in an amount in excess of 1,000. That would make it a corpus, an element of the crime, right?
Yes.
And then it says it's an E felony if it's in excess of 1,000. I'm wondering, it would seem to me that line 125 would be better suited to say less than, in an amount less than $1,000 at the end of the line.
I'd have to look at that further, but you might be right. There might need to be a fix there.
Okay. You see what I'm saying, right? Because you're creating two elements for separate offenses, separate degrees of offense, both in excess of 1,000.
Right. Yes.
That doesn't, you agree with me? It doesn't make any sense.
Correct.
Okay. The next thing, staying in that same section 5 on line 123, it seems like, and Rep. Fishbein just said this, like wearing a mask is a D felony, which I don't know, it's fine. But why are we going down to an A misdemeanor when we're talking about religious property? Why have we as a state, as a matter of public policy, going to make it less of an offense when we're affecting religious property? Because everywhere else, it seems to be D felonies, E felonies, C felonies. And for some reason, in this particular section, we're detracting from that to go to an A misdemeanor. I just don't know if there was a rationale for that.
I stand corrected, but I believe it's because our existing law may have that inconsistency, and that's partially, in fact, due to the fact that these crimes are spread out and have some inconsistencies inherent with them. So,
Well, section 5 is new, and which is my next question. I don't understand why we need section 5 if section 4 exists. I guess my point is, I guess I need to understand why we need, it seems section 4 already does this. Section 5 would seem to be a bit redundant to me. That because in section 4, a person is guilty of hate crime affecting property when such person, et cetera, which is an E felony or a D felony, depending. But then we're going to create a separate class for religious property and make it a less an offense. It seems to be what we're doing. And I'm trying to understand that. And I could be, again, I could be misunderstanding it.
and again, I think my only answer for you today is that I believe that's incorporating a different statutory section that exists in our current law, maybe 46A 58. I'm not entirely sure, because there are a couple that touch on this issue, but
Okay, and in your dialogue with the ranking member, he asked about the urging or the organizing, et cetera, a part of this. And we have a statute, 53A 178, inciting a riot. Is it, was this drafted, modeled after that perhaps? Because that says, when somebody advocates, urges, or organizes, and that it's 6 or more persons, it's a bit more involved. Was it drafted after that particular statute? Do you remember?
it may have been, but I just don't recall, and I don't
Okay.
have it at my fingertips. I apologize.
Thank you. No, it's okay. And my last question, and if you, I'll phrase it as a question, but just something that I like for you to comment on, if you could. One of my former colleagues used to approach me every year and say, I think strangulation 3 should be a felony. Now, I have my own opinion on what should happen to people when they strangle their spouses, but that's not appropriate for here. And I've always pushed against that because I know what happens in pretrial plea bargaining, which is how, can we agree that's how most of the criminal cases in this state are adjudicated?
Yes.
I know what happens. People sit there and they say, well, I'm willing to admit guilt, but I don't want to be a felon. So the courts, in agreement with the attorneys, they sub in assault 3, or they sub in breach of peace, or they sub in something else. And the point is, strangulation, in my experience, is a significant indicator of a specific level of violence that somebody's willing to conduct or perpetrate on somebody else. When we do those subbings like that to avoid the felony conviction, which happens, we agree on that, right? That conviction comes off their record. That red flag, if you will, or that indicator of the future propensity for significant violence, they were never actually convicted of, which makes law enforcement's job much more difficult. I tell you that story, and thank you for indulging me on that, because in many cases in this bill, we do the same thing, right? We create similar things, mandatory minimums. My concern is this: much like strangulation is an indicator of the specific level of violence that somebody's willing to perpetrate, committing a crime against somebody solely for who they are is a very specific level of evil, in my opinion, in my experience, which is 23 years. I'm concerned that the mandatory minimums are setting up a scenario where deals will be made to avoid that. So for example, if there's a minimum $1,000 fine, and I have a client as a defense attorney and say, well, he can't afford the fines. If you sub in something else, we'll give you the 30 days jail, three years probation if you sub in assault 3 because he can't afford the fines. And that's the only way to avoid it. Maybe the prosecutors take that deal, and now we don't have that conviction of the indicator of the level of evil they possess. Does that make sense what I'm saying?
It does.
And you agree with me that happens a lot in our state. I'm not criticizing your office. I understand there's reasons in every circumstance, but can we agree that happens a lot?
It does.
So is there a way that we as a legislature, as a matter of public policy, can make it clear to the judiciary and the chief state's attorney's office, and probably in part the defense counsel too, but the level that the people think is appropriate for those who commit this crime, people being the legislature, without hamstringing prosecutors and judges into that box? Is there a way that we could do that? If you have a comment on that now, or we could talk about it later, I'm happy to. I think these people should be prosecuted significantly. I don't want to, in our attempt to do that, set up a scenario where we're doing what I just explained.
That's a very long question.
I'm sorry.
But I'm not sure I can fully answer it, but I can say that we can start by calling these crimes what they are, which is the primary purpose of this bill, and put them in one chapter so that our law enforcement can find them, charge them correctly, so that prosecutors can understand them and prosecute them. We have some statistics from 23 and 24. There are approximately 80 dispositions on what we would call the top 6 most commonly prosecuted bias-driven crimes in our state. And it includes the 53A 181s and a few others. And of those 80-some dispositions, about 40 ended with a conviction on one of the crimes charged, hate crime or not hate crime. Of that half, approximately 40, half of those actually get a conviction on the bias-related offense, whereas double the number. In other words, I think it was 17 in 2023 to 32, and it was 12 to 25, the ratio number of crimes in 2024. And what that says to me is that our prosecutors are not confident that they can get a conviction on the most serious, readily provable offense because these statutes are so difficult to understand and apply. So I see your concern about the plea bargaining and how do we structure it, but I would advocate that the first step is to call the crimes what they are and to make them easy for our law enforcement to investigate, prosecute, and get convictions on.
And last thing is when you say call the crimes what they are, and that's really important. And I think it's an important distinction that folks in this committee and folks listening should understand. And I think the way this is drafted and has been drafted, specifically with the language, motivated in substantial part or wholly or in substantial part, however it's worded here, is important, because I think folks need to understand, and correct me if I'm wrong, it isn't a hate crime because the perpetrator and the victim are simply in different classes, or the victim,
Absolutely. No.
right? So I think, but that's a sort of misconception, right?
Yes. Yep.
And I think that's one thing that I think is made clear in this bill. I think it was clear before, it's clarified even more, that simply because myself and another person who happen to be of different races get into a bar fight over a game of pool or something, it's not a hate crime. But if I walk in and see somebody of a different race and just randomly assault him because he doesn't belong there because he's of a certain race, that's a hate crime, right?
Exactly.
Right. So, and I think that do you agree then that the language here sort of really narrows that down to the best degree that we can to try to get to what we're doing? I think it does, and I would imagine you're in favor of the bill. You would agree.
I do.
Okay, and I thank you so much for your time. Thank you, Mr. Chairman.
Thank you.
Thank you. Let me just drill down on that a little bit, because I do think sort of this motivated and substantial part is kind of critical for us to understand and sort of how that goes. So let me go back to section 14 for a second, which was the one on masks, and just give you sort of 2 scenarios that sort of I'm playing through in my head, and I'm trying to figure out kind of how this works. So there's a 19-year-old kid, and he's standing on the street corner in front of a shop, and he's got a surgical mask on, not surgical, but one of those masks we all wore during the pandemic on, right? And shopkeeper comes out and says, older gentleman shopkeeper, he comes out and says, "Hey kid, stop loitering in front of my storefront. I want you out of here, da 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 da," right? The kid turns around to him and says, "Shut up, I don't want to hear from you. Shut up, shut up, shut up, stop talking, stop talking, stop talking," and sort of shouts him down, right? Free speech is a right protected by the First Amendment, correct?
Yes.
So depriving someone of their free speech rights, shouting someone down, could be a deprivation of a rights, privilege, or immunity protected by the Constitution.
As you say, yes, if it was in the manner that it is literally drowning out,
Drowning 'em out.
yes.
Drowning
yes.
them out. So
The
they're
conduct of speech, the loudness, the interference that it's causing,
Right.
yes, but not the words itself. Yep.
so right. So you're drowning them out the speech. So if that shopkeeper happens to be over the age of 60, because elderly is defined as over the age of 60 in this bill. Just the fact he's over the age of 60 doesn't make that a hate crime for drowning out his speech, right? Just
Correct.
because the 19-year-old does. But what happens if in the act of drowning out, that 19-year-old kid says, "Shut up, old man. I don't want to hear from you. I don't need to hear from old people like you. Your time has come and gone, whatever. We don't need any more boomers yelling at us," whatever he's saying, right? Is that motivated in whole or in substantial part? And is that kid who, because he's wearing a mask and he's getting yelled at for loitering, is he now guilty of a D felony?
Representative Sastrom, this is like an excellent law school question that I'm so excited to answer. I think there's a couple, there are a couple things in play. Number one, we could probably argue about whether a hospital grade mask is actually designed to conceal identity. That would be a fact that we would bear the burden of proof, and I'm not sure we would prevail on that beyond a reasonable doubt at trial. But to your other point about the age, I think it could be. I think it also I'm not sure we would be able to meet our burden of proof, but under that hypothetical, yes, I think technically it could qualify as this type of crime.
See, and I think that's our concern, right? As we look at sort of legislation, it's, we need to be careful we're not unintentionally writing what are very well-intended statutes, right? Obviously, I think we all share the belief in certainly preventing and prosecuting hate crimes, but how do we draft this stuff narrowly enough that we're not unintentionally capturing in? I mean, maybe I'm in the minority, but I don't think that 19-year-old kid should be guilty of a D felony for getting in a shouting match with the shopkeeper, right? But no matter what his words may have been. But I think we just need to be kind of careful in how we draft this. And I guess that's where, I think substantial part just gets sort of gets tricky because, where is the line on substantial part, right? Particularly when we're talking about speech. I think when we're talking about actions, it's a different thing, but when we're talking about speech, it becomes, there's a lot of gray area there.
Understood, and that's why other states, like even Massachusetts, our close neighbor, employs a slightly different standard. They say at least in part. The federal language, I believe, is slightly different as well. The whole or a substantial part is just part of our existing body of law, but it's certainly another aspect that this body could look at amending in connection with a whole cloth revision of the statutory scheme.
Okay. Yeah, no, I appreciate that, but I guess what I'm trying to figure out is I thought this bill was supposed to be a cleanup, and it seems like there's at least some additional cleanup that still needs to happen.
Understood. And I think, and again, I defer to the professors, but the attempt was to authentically put together everything as it currently exists in a way that it makes sense, which doesn't mean that our laws, as many other laws, aren't also amenable to further tweaking as we continue to use them and understand our law a little better.
Understood. Senator Winfield.
So I will admit that sometimes when you're sitting here, if you miss one word, you have a little trouble following the rest of the conversation. So maybe you've indicated the answers to my questions. I'm not sure. But I think I just heard you say that part of the problem you would have under the scenario as presented by Representative Stastrom is the design or the purpose for the design of the mask. So this strikes me as a little strange because in conversations I've had related to this bill, some of the conversations, I don't want to represent it as all of the conversations, but in some of the conversations I've had related to this bill, it seems to be suggested to me that while those masks were used for a certain purpose during the pandemic and have been used for related types of purposes subsequent to the pandemic, it in fact would hopefully capture times when a hate crime was committed using those masks. That's certain people's opinions, not everyone's. But if the design is at issue, then I wonder, like the types of masks I think most of us would imagine are trying to be captured here also would suffer from a design issue, right? Whether that be one of the most controversial things we talk about right now, the kafaya, which is not designed to uh, uh, keep your identity from being known, or what some young folks refer to as a shiesty, which is not designed to do that, but can be used that way. So help me to understand what this does then, because I'm confused. I thought we were doing one thing, but given what you said about the design, I don't feel like we're necessarily doing that.
So the term mask is not defined in our statute, and this is a statutory section that I believe actually first was enacted in 1982, which was following a revival of some Ku Klux Klan activity in the state. But again, the term mask isn't defined. So I think that the point I was trying to make, although maybe inartfully, was just that because it's not defined, it's always going to be subject to a jury instruction and a jury making that determination as to whether the mask was in fact designed to conceal identity, which is going to be most often circumstantial based on the facts of the case, how it's being used, what part of the face it was covering. I'm not aware of any case law actually litigating this point, so I'm not sure that this is something that we even have a solid handle in terms of what it means under our law. So, but it is in our existing law, and it has been on the books since the early 80s.
Thank you for that. I accept that. It is a little disturbing to me, though, whether we've had law that's significantly the same or not, because we are in an effort of potentially voting for and passing a law that should have the meaning that we intend. So I'm not sure what we intend, exactly what we intend. And by the way, I'm going to have to stand up on the floor and defend this. So I would really like to know what we intend. And I do share Representative Staffstrom's concern about the state of this bill. Look, I know there are hate crimes. I've experienced them. I've had some folks in positions that should never say these things say that I should be dragged in chains back into slavery and many other things that make that look mild. But I do want to make sure that we get this correct. So thank you for answering my question. I appreciate it.
Further questions or comments? Further questions or comments? If not, appreciate being with us.
Thank you very much.
Leanne Almeger. Ruth Larson. Ruth Larson with us. But Tanya Hughes. Good morning. Turn your microphone on for me, please.
Good morning, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and members of the Judiciary Committee. Thank you for raising Senate Bill 1442 at the request of the Commission on Human Rights and Opportunities, and for the time to offer testimony in support. I'm Tanya Hughes. I'm the Executive Director, And we've submitted written testimony, so I will summarize a few highlights of the bill before taking any questions that you may have. Sections 1 and 2 add the new definition of employer's agent to Connecticut General Statute Section 46A51. This change is due to a 4-3 court decision from 2024 in which the Connecticut Supreme Court adopted the federal definition of supervisor or employer's agent in the terminology of the CHRO statutes for purposes of state employment law. This federal definition is overly broad and is narrow, defining as a supervisor only individuals invested with the authority to make or recommend tangible employment decisions. In order to best effectuate the purpose of the anti-discrimination statutes, we need to broaden this definition that also includes individuals who are authorized to direct their daily work activities. As described in our written testimony, the definition in Section 1 of the bill reflects that offered by then Chief Justice Robinson in his dissent. It is not uncommon for a job, especially in workplaces that rely on hourly or low-income workers, to involve an employee interacting day-to-day with their immediate superior who directs their daily work and schedule, but who does not have the ability to fire them. Sticking with the more narrow federal definition of supervisor would allow employers to avoid vicarious liability even when a superior has this sort of control over an employee's daily work. This does not expand liability for individuals, however. What it does is closes the loophole of who can be considered an employer's agent. The remaining sections of the bill largely aim to clarify the timing and process for certain proceedings at CHRO. It clarifies that the early legal intervention process, also known as ELI, cannot be requested after the issuing of a draft investigation report, and that the reopening of a complaint cannot be requested once a final decision is issued by the Office of Public Hearings. It also aligns the deadline for filing in court following a release of jurisdiction with the federal timeline. More details on these sections can be found in our full written testimony. And with that, I'm happy to answer any questions. I have with me our legal managing directors, Attorney Michelle Dumas-Kuhler and Attorney Kimberly Jacobson, who can answer any additional technical questions.
Thank you. Questions, Committee Rep Fishman?
Thank you, Mr. Chairman. Good morning.
Good morning.
Focusing on the employer's agent expansion, can you give me a scenario where that was, where this language is necessary?
So, for example, in a fast food industry, many times the supervisors do not have direct authority to terminate or to hire. However, they do determine what their schedules are, when they come in, their daily work activities throughout the day. And the employees can be subject to a lot of discriminatory activity by people who don't necessarily have the authority to hire or fire them, but the employer is responsible for that activity, and this broadens the scope of that.
Understood. So why is it insufficient that the employer who employs the supervisor, right, would be held liable in that's currently the law, right? The employer, they are, why do we need to go to the next level? I understand that that person could be a witness, right?
Right.
But now you are looking to expand this to someone, the intermediary. Why is that necessary?
I think it broadens the interpretation and defines it in our law.
Well, I understand.
If I could invite one of
understand
our.
what it does, but
Yes,
I'm just trying to figure out why is it insufficient? Because if that action is happening, right? So let's stay in the fast food restaurant, right?
yes,
John Smith owns the fast food restaurant.
correct.
He hires Peter to be the supervisor of Paul, right? Peter is discriminating against Paul. there's liability for the employer, right? John Smith, liable, you can bring an action under CHRO. Why do we need to make the intermediary a party here?
Good morning. So I'm Michelle Dumas-Kuehler. So our interpretation of the statute prior to the.
Hold on, just for the record, just spell your last name and give your title,
Sure.
please.
It's Michelle with two L's, Dumas, new word, Keuler. And I'm one of the managing directors of the legal division at the Commission on Human Rights and Opportunities.
Thanks.
So our interpretation of the statute prior to the Supreme Court decision was what our statutory change is meant to effectuate. So vicarious liability is something that we always interpreted for every kind of level of management. Prior to the Supreme Court more clarifying this by adopting the federal standard under the Vance decision. So prior to this, we were interpreting it that any level manager who committed the discriminatory act would then make their owner, whoever was above them, vicariously liable for that act. And so the Supreme Court's decision last year turned that back around to essentially say that only the person, kind of really the top person, the person who either owned the company or was like the division head, who had the ability to hire and fire, which is pretty high up in terms of level of management, would be the person who would then attach liability. But there's lots of levels of management. And so our change to the statute is to incorporate how we were already interpreting the statute essentially, which is any of those levels of management who committed the discriminatory act would then make the actual company owner, whoever it may be, vicariously liable for that act.
Even though the owner of the company may not have knowledge.
Well, they would have knowledge by the vicarious liability of the actions of their agent, who is the lower level manager. And that's how it worked before and how we investigated before, how the vicarious liability piece of it has always been interpreted by the agency.
Yeah, I'm just concerned, because obviously I don't want this to happen at all, right?
Correct.
So I don't want it to even come before you.
Right.
So from my perspective, there should be knowledge at each level of the discriminatory practice, but it appears that what this would allow someone to do is not report to their supervisor's supervisor and to bring an action they would have standing here.
They wouldn't normally. It's just a matter of the knowledge piece of it, correct?
Okay. Similar with the hate crime legislation, we have this expansion to status as a victim of domestic violence. I think we've dealt with this in past years.
Mhm.
What does that mean? Because it's undefined here.
So we have our definition within our statute of what victim of domestic violence is. We are not the drafters of this bill, and I know they're testifying today. We were involved in the language for purposes of cleaning up our statutes that had vestiges of hate crimes in them. We work on the civil side, not on the criminal side. So that was the extent of our working with that group. Our definition of victim of domestic violence is what we employ for us. I can't ultimately speak to the criminal definition. And
No, I'm talking about your bill, 1442, right? That's your bill.
Right. But
Okay, so-
you talked about hate crimes though.
I said similar to the
Oh,
hate crime
okay.
bill,
Okay.
okay?
Yes.
If you look at lines 137 through 142 in your bill,
Yes.
you are adding to,
Oh, yes. So we already, so that language is already added a couple years ago. What ended up happening was when we were looking at the statute, we noticed that victim of domestic violence was only in section 1, paragraph 1, as a protected class, and it was not in any of the subsequent paragraphs down 2, 3, 4. So we thought it was a Scrivener's error, and so we're just including it because it wasn't carried down through the rest of the statute.
no, I understand a lot of stuff happens in the building,
Right.
even though we get up and tell them it makes no sense.
Right.
It happens anyway. I'm trying to figure out since that term, and I think I've pointed this out before,
Mhm.
is not defined, what does it mean? I mean, in the hate crimes bill, once again, I'm going to that bill, they deal with 46B1 as the definition. I'm trying to figure out where's the link up here, and what's the adjudicative determination that one has that status? Do they have to have actually had a case? Is it merely that they claim it? Where is that stuff?
Sure. So, so under 46A51, paragraph 25, we too link up with 46B-1 as our definition of a victim of domestic violence. Somebody would allege that in a complaint to us, and then they would have to, by ultimately a public hearing, a preponderance of the evidence, show that they were a victim of domestic violence, and that discriminatory things happen to them because of that, either in their work environment or in housing.
Okay, I'm trying to, you said at the beginning that there is some reference in the
Correct.
CHRO statute.
Yes. So under
Link up to
46A51,
46B1.
yep, 46A-51 is our definition section of our commission. And so if you, and it's actually in the bill that you, hopefully in the bill that you have before you, it's on line 94. It's section 25, domestic violence, has the same meaning as provided in subsection B of 46B-1.
Okay, I see that now. Thank you.
You're welcome.
And it seems like this is like, what is that, Groundhog Day? Because I've asked this before. In practice,
Mhm.
how does your office handle, what's the threshold determination as to whether one has that status?
So somebody alleges it in their complaint, and we will do an investigation on the allegation. And as an example, I can give you an example right now. So we have a situation where it's a housing complaint where the housing provider has taken certain action against a tenant who has an abusive relationship with a sibling. They're all adults. And so some of the housing situation that's going on is, or the negative situation, lack of payment of rent, is based on this domestic situation with this person's sibling. So that
So
would
then
be,
your office ends up adjudicating the veracity of the domestic violence claim?
so not necessarily, we're not the criminal side of it, we're the civil side of it. So we would investigate the veracity of the claim as it relates to the housing discrimination, whether a housing provider treated this person in a certain way because of their membership in this protected class. Like any other protected class, we investigate everything the same way. If the allegation is a victim of domestic violence and the housing provider was acting in a certain way because of that, which this housing provider was on notice, there was police calls to the residents, we would investigate it for that. And the investigative standard for that is reasonable cause. So it's not a preponderance of the evidence standard, which would be the civil court or OP or Office of Public Hearing standard. So, so they make the allegation and we investigate whether the housing situation is affected by the allegation that they're a victim of domestic violence.
Okay, it seems like the tail wagging the dog, but I don't know how you could possibly, because if the claim is that the bad act is happening based upon there being a victim,
Mhm.
how your office could not get involved in determining whether or not they were a victim under 46B1.
Mhm.
I don't know how that happens, but you'd have to get involved.
At some
just
level.
because,
Yeah,
I mean, people,
agreed.
cops get called to people's houses for various reasons. So merely because the police came to the house.
I think there's other telltale signs, particularly in housing too, where, people see people in their everyday lives and may hear things, there might be disturbances that they hear in the units or complaints are made by other tenants. if there's physical abuse, they could note it on the tenant. So it wasn't always like this big surprise when they get the complaint that this person was a victim of domestic violence. There's usually other things that are going on that would put the housing provider on notice.
But at the end of the day, you know, I want people to get help for domestic violence,
Of
right?
course.
And going to CHRO is not getting them the help for the domestic violence. So,
And we do too. It's not necessarily easy for everyone to do that though, too, in terms of how somebody reacts to the situations that they're in and the safety they feel in those situations.
totally understood.
Yeah.
I got it. So, but thank you, Mr. Chairman.
Further questions or comments? Let me just clarify, back to section 1, right? I just want to make sure I'm understanding
Mhm.
the net effect of the change. So back to Representative Fishbein, let's use, you know, John's Pizzeria, and I forget, I guess Peter was employing Paul, right? But so Peter is directing the schedule of Paul, and Peter is discriminating against Paul,
Mhm.
right? Under this language, can Peter be held personally liable for discrimination?
No, there's no, the intent of this and the way it's written is not to extend personal liability to any employee beyond what already exists, which would be aiding and abetting, which is already in our statute. So it's just a matter of whether vicarious liability attaches for the behavior of that. I keep forgetting who Peter and Paul is, whoever the supervisor is.
Well, yeah, whoever the
Maybe no distinct
supervisor is.
names. So whoever that person is, it's more so putting the ultimate supervisor, person who makes hiring decisions on notice for the behavior of that kind of mid-level supervisor. But it does not, I know that there's been some testimony about that. It does not create individual liability for that manager.
Okay. Because I'm reading, I guess I was reading through sort of the testimony from the CBIA on
Right.
this, and I think their concern was this was an expansion of liability to really sort of the individual employer, or I should say the individual supervisor.
Correct.
And it's your testimony that
It
their
does not. Nope, it does not.
CBIA is wrong. In a nutshell.
Do you want me to- you can say that.
Okay. No, I'm asking
Yeah.
your testimony. You
Yes,
disagree
so
with their position.
CIA might have misread what the language was, but we are not, there's no individual liability in this bill. It is more so, like I said, to put back into place what we deem as a vicarious liability to the ultimate owner, whoever that higher person is, from the intermediary manager for their discriminatory acts. But it does not create individual liability for that manager and for any other person beyond aiding and abetting, which is already in the statute.
Okay, because that was my understanding. I had the same understanding you guys did. I just wanted
Perfect.
to make sure we were clear on the record.
Yep,
about
that is correct.
Okay. Representative Fishman?
Mr. Chairman, for the second time, but what about the instance of a DBA, somebody who is, you know, they're not a corporation, they're not an LLC.
Mhm.
The individual will be held vicariously liable. in
If
that
they're the
case.
owner and they're deemed an employer under our definition of employers for the state, then they would be liable as the owner of the entity.
As the individual.
Well-
No, there is no entity, there's a DBA. So they're self-employed and they bring on supervisors, you know, it's John's Landscape Company.
Mhm.
And they're all over the state and they choose not to be a corporation or an LLC, but they
Mhm.
are, they trade name certificate their business.
Mhm.
That's individual liability.
It's corporate liability for the LLC.
That's
The
not-
individual liability is not,
They're not an LLC.
they're an employer. We're talking about the definition of employer under our statutes. They're considered an
Hold on,
employer.
I want to slow you down, because I hear conversation happening at the same sorry. I hear conversation happening at the same time, and we're going to not be able to follow. So
Okay,
I get this is a point of contention. Slow it down a little bit.
Sure.
Let one person finish and then the other speak.
Where there is not an LLC
Mhm.
or a corporation, the individual would be held liable.
The individual owns a company, correct? They own a
It is
business
not
where
a
they employ people.
corporation or an LLC. It is a DBA,
Mhm.
doing business as. That is an individual. So the individual in that instance would be held personally liable.
The individual has employees.
Yes,
So the individual is the employer of these employees. That individual is going to be liable as the
personally
owner
liable.
of the,
Yeah.
because they own the business.
Thank you. Thank you.
I,
Mr.
I
Chairman.
think we're talking about two different things. Not to debate this, plenty of time for that, but I just want to make clear, I think what we're saying is the ultimate employer, whether that's an individual or whether that's an LLC, corporation, whatever, through vicarious liability, they're liable and going to maintain. My question was not directed at that. My
Correct.
question was directed at the intermediary supervisor, right? The person who is not McDonald's, but they're the store manager at the McDonald's or the shift supervisor at McDonald's. I think the fear or the testimony, at least the way I read it from CBIA, was that this bill would extend liability to that shift supervisor at McDonald's. I don't read the language that
Mhm.
way. It sounds like you all don't read the language that way either. And
That's
so
correct.
if we needed to clear that up in the drafting of this, we could. And, McDonald's remains liable, but the shift supervisor is not assuming liability.
That's correct.
Okay.
Yes.
Representative Fazino?
Thank you, Mr. Chair, and thank you for joining us this morning. Going back to the definition of employer's agent, line 101 specifically, talks about a recommendation of a tangible employment decision. I'm just trying to conceptualize what rises to the level of a substantive employment recommendation. So I'm just using my own experience at my firm. I'm middle management. I'm not involved in any sort of hiring or firing of employees, but to what extent would my input regarding a specific employee rise to a level of a recommendation regarding their employment status at a company?
So say if you're middle management and you're supervising an employee and you notice their work is slipping and maybe you want to, put them on a performance improvement plan. You want to do something, but you don't have the essential power to do that. The manager above you has the power to do that. You're kind of more on the ground with that person potentially. So you could make recommendations to your above supervisor as to how that person works. If they needed some, either way, you wanted them to get an award or you wanted them, to go on some improvement plan, you would be that intermediary who would control that level of their work, even though, again, you don't have the power to hire, fire, do those types of things.
And so could it be as simple as just popping into their office and saying, hey, Smith is having a really bad stretch of performance. I think it would be worth having maybe a substantive conversation about their performance, or does it have to be more formal, such as an end of year evaluation, performance evaluation, mid-year, informal, formal? Where do you kind of draw the line?
I think it could be either. I think because ultimately you have this kind of intermediary supervisory power over this employee. And so you have then the ability, need, requirement to speak to the person above you. And it could be in any fashion. That's all going to be up for fact finding and interpretation as to whether your contact was enough. But that's almost not the issue. The bigger issue is who you are having the interactions with and how you're controlling their work. That's really what sets you into that definition as opposed to who you're communicating with about it later on.
So it's almost a factor to be considered as to whether or not this person has agency over an employee's future at this company, as opposed to a dispositive, all right, this person made a recommendation to their boss and the boss is going to act on it, and that rises to the level of being an agent. It's one of a multi-factor test as opposed to just the one single
Correct.
factor. Okay, I got it.
Exactly.
Okay. Thank you.
Further questions or comments? Seeing none, appreciate being with us.
Thank you.
All right, looks like we have Caro A back with us.
Hi, thank you. Dear members of the Joint Judiciary Committee, my name is Caro. I am a resident of New Haven and a member of New Haven's Jewish community. I am testifying in opposition to House Bill 6872, an act revising and consolidating the hate crime statutes. This bill opens the door for selective enforcement, where activists can be penalized for dissent rather than genuine hate-based violence. Right now, expansion of hate crime laws to facilitate their use against pro-Palestine anti-genocide protesters is part of the right-wing playbook outlined in the Heritage Foundation's Project Esther. And we cannot let this right-wing playbook be written into Connecticut's policies. Organizations like the ADL and the Heritage Foundation have been putting Jewish communities in danger as they use false claims of anti-Semitism to push forward repressive policies, all while collaborating with right-wing zealots who regularly espouse anti-Semitic conspiracy theories and racist hate speech. We cannot let false definitions of anti-Semitism be used to place regressive laws into place that repress our civil liberties. I'm also very concerned about the language in this bill about masks. While I'm hearing that this language mirrors the language in existing laws, the state should use this time to seriously consider the implications of this anti-mask language, written as vaguely as it is. We are seeing the right wing enact mask bans across this country to make it easier to punish protesters. And with over 100,000 Americans still dying every year of COVID-19 and millions more developing long COVID, the pandemic isn't over, and there is every reason to continue masking to keep ourselves and each other safe. Further reason to wear masks is that we're seeing a troubling rise of the unregulated use of AI facial identification software by police departments. And the Trump administration has also announced it intends to use AI to identify and arrest protesters. With the Trump administration clearly expressing these intentions, this is not the time to further criminalize mask wearing or to make it easier for police to arrest people with unclear definitions of hate crimes. The police are not immune from the racism, sexism, and other prejudices that cause hate crimes, and these biases will inevitably influence the way this policy is applied, with Black and brown folks inevitably being targeted more often and dealt harsher charges. The mountain of evidence about racial bias in policing indicates that as a white woman wearing a mask, the police is far less likely to see me as a threat than if they were to see a Black woman or an Arab man in a mask. So under this bill, marginalized communities could be at increased of violence. This bill will make my Jewish community less safe, and it will make all Connecticut residents less safe. So I urge the state to do more to address hatred and bigotry at their root cause.
Thank you. That was the bell. Questions from the committee? Questions from the committee? Seeing none, appreciate being with us today.
Thank you.
Ruth Larson.
Hi, this is my first time testifying, so if you don't mind, I'm going to read my statement. As my statement is written, it says, members of the Joint Judiciary Committee, my name is Ruth Larson, and I'm a resident of Wethersfield. I'm a parent, healthcare provider, and community activist. I'm testifying today in opposition to the Governor's Bill 6872, an act revising and consolidating the hate crime statutes. The bill, as proposed, would have a negative impact on the problem it claims to address. It would allow for an increased police presence among marginalized communities and the repression of organizers and activists across the state. As a parent of 2 young children, I'm thinking of what their futures will hold and what their lives will be like. And I would hope that they would have the same freedoms and rights as we have now. I would hope that they feel empowered to speak out against injustice where they see it and work for a better world, particularly for those in historically marginalized communities. This bill's vague language and enhanced penalties could increase police surveillance of those advocating for the rights of those who are disadvantaged, discouraging participation in social justice movements, while further insulating law enforcement from accountability. Without clear definitions, authorities may exploit these provisions to suppress dissent rather than combat actual hate-based violence. Lawmakers must ensure hate crime protections are not misused to criminalize protest and political expression under the guise of public safety. We do not need our democratically elected state government taking measures to silence our voices. We need our state government to further protect our free speech and advocacy work, not undermine them as this bill would accomplish. This bill, while framed as a way to protect marginalized communities, does the exact opposite. The changes enacted in this bill will open a new method to exploit our legal system by allowing the weaponization of hate crime laws to suppress legitimate political dissent and opposition in our community. Thank you for your time. I urge you to vote no on Governor's Bill 6872. This bill not only risks fostering a dangerous precedent by protecting political ideology and occupation, but it also has the potential to increase police repression, further marginalize activists, and deepen societal divisions under the guise of combating hate. I would urge the Judiciary Committee to send this bill back to the working table and to examine the contradictions, clarify the definitions, and re-examine the broad implications of this bill as it is written. Thank you for your time.
Thank you. Questions from the committee? Senator Winfield?
Yeah, not a question. Just you remarked that it was your first time. You did a pretty good job.
Thank you.
Well timed too. Further questions or comments? If not, thanks for being with us this morning. All right, next up will be Commissioner Rennell Higgins.
Morning. Good morning, Chairs Winfield, Staffstrom, Ranking Members Kissel and Fishbein, and distinguished members of the Judiciary Committee. My name is Ronnell A. Higgins, and I am the Commissioner for the Department of Emergency Services and Public Protection. I want to thank you for the opportunity to come here this morning as I urge you to strongly support HB 6872, an act revising and consolidating the hate crime statutes. This bill will consolidate and strengthen the state's existing hate crime statutes. The fragmentation of these laws across 21 sections of the general statutes has created confusion, making it more difficult for law enforcement and prosecutors to hold offenders responsible. We have seen nearly a 50% rise in hate crimes in the state of Connecticut since 2021. 130 hate crimes were committed in the first 3 quarters of 2024. As we all know, hate crimes are not individual events. The anger, the anxiety, and the vulnerability ricochets across our neighborhoods and our entire communities. As part of this initiative, what DESP has already done is expanded our outreach, our investigative, intelligence, and enforcement initiatives, which will be made easier by this consolidation. Recently, we added the head of our interdisciplinary approach, the leader of our external affairs, Mr. Michael Bloom, who served for many, many years in this space. We believe that advancing some of the initiatives recommended by the Hate Crimes Advisory Board Council in 2023 in their annual report will help Connecticut become a safer place. Again, I commend Governor Lamont and his committee for its leadership on this important issue, and I urge the passage of this bill.
Thank you. Questions for Commissioner Higgins on this? Questions for Commissioner? Let me ask you. I think 2 of the sections that were touched on briefly that I think are probably causing, at least in some of the written testimony we've gotten, kind of some of the most concern are sections 24 and 25, which appear to impose a mandatory minimum sentence, which, as you and I have discussed many times, is something that I look at very, very carefully and cautiously. I think mandatory minimum sentences, just as a rule, are really counterproductive to best criminal justice practices. It really, it takes away discretion from judges. It doesn't allow a judge to sort of look at the individual circumstance of the case and impose a sentence based on what somebody's first offense, ninth offense, you know, what the circumstances are. But I think I think these sections in particular are causing me a little bit of concern just on the way that it's drafted. I think it's lines, just lost my place. Yeah, so it's lines 367, 368, 369. If the finder of fact determines beyond a reasonable doubt that the defendant intentionally selected, when is that finding made? Do you know? I mean, is that a finding after trial? Is that a finding as part of a plea agreement? You know, how do we make that finding?
I believe throughout the course of the investigation, an investigator could determine based upon the evidence that a perpetrator did in fact select a victim based upon in whole or substantially in part of their immutable appearance in the public.
So if there's an allegation from the investigator, which I guess could be the local police department, that would be enough to give a rise to the imposition of the mandatory minimum? That doesn't seem.
No, they would have to.
Yeah.
They would have to go a little further.
Okay.
Representative Staff. They'd have to prove it. They'd have to be able to defend their decision.
Okay. All right. Further questions or comments, Representative Fishbein?
Thank you, Mr. Chairman. Good morning, Commissioner.
Good morning, sir.
You know, I'm searching through the statutes and, you know, because we've heard, and I agree with consolidation and, you know, getting this stuff all in one place. It's easier for everybody, right? But this term, it seems to be an expansion of now calling, doing something, this protected social category, status as a victim of domestic violence. Is that an expansion of the hate crimes area?
I have not seen that in the past. I believe that was something that may have been added by the authors.
Okay, so this is more than just a consolidation. This is an expansion.
More of a consolidation, but again, I can't speak to what the intent was in putting that in there, but my reading of it for the purposes of law enforcement was to consolidate the laws in one place to provide certainty to the police, more certainty.
Okay. And what is, as the commissioner of deaths, what is your position with regard to that particular expansion?
You know, the purpose of our work, the hate crimes investigative unit, which my agency oversees, is to investigate, compile, monitor, and analyze data and share data, and also assist other law enforcement agencies in the course of their investigations. So whether it's a property crime or a crime against a person, we're here to assist.
Understood, but here, this whole scheme, which, you know, hate crimes are bad. I can't say differently. It takes a property crime, it takes a crime against a person, and it takes it to a higher level, right? Because, you know, if a neighbors get into a spat, maybe it's an assault third, but if neighbors get into a spat because one person started the fight because one person happens to be of a particular race and, you know, is yelling, you know, racial things during that escalates from an assault third to a hate crime, right?
Mhm.
So I sort of have the same situation here with the domestic violence aspect. I mean, personally, I think it dilutes that scenario that I was just giving you. But I understand you're, as the commissioner, you follow the rules, you administer, and you essentially take no position on the expansion.
I take no position on the expansion. However, I will offer one scenario wherein you can have two college roommates rooming together, okay, and they get into a fight or a spat and a racial epithet as a result of, or some race, gender, ethnicity, or something comes about as a result. Um, then that would bring in domestic violence. So it's not inconceivable.
Yeah, I mean, I think you're sort of proving the point that because they're roommates, that spat becomes an act of domestic violence absent the racial epithets, right?
Well, it depends. If it depends all, why they're fighting. Why is this happening? Are they was one hitting another and saying, racially charged things as a result? Did one learn of the other's sexuality and all of a sudden decide to assault him or her as a result of that? All of that, in my mind, would come into play.
Understood, but my point was that because they are roommates, if they get into a fight, that is a domestic violence crime.
Yes. Yes.
Okay, thank you. Thank you, Mr. Chairman.
Further questions or comments on this? Further questions, comments? If not, Commissioner, it was good to see you. Thanks.
Good
for
to see you. Thank you.
seeing us. Amara E.
Hello. Well, thank you, members of the Joint Judiciary Committee. My name is Amara. I'm a resident of New Haven, and I'm testifying in opposition to Governor's Bill 6872, an act revising and consolidating the hate crime statutes. I appreciate the level of scrutiny that you all have been putting towards this bill today. I'm in opposition because, like many people have already said, the bill lacks clarity on whom it aims to protect, and it makes it vulnerable to misuse by Zionist, neo-Nazi, and right-wing extremist groups to suppress dissent. Hate crimes are contextual. Existing hate crime statutes recognize acts like cross burnings and news displays as being due to the deeply rooted racist history of the United States. Similarly, Zionism operates as an extension of white supremacy and fascism, engaging in genocide and the ethnic cleansing of Palestinians. That piece of advocacy being made criminal against systemic oppression and violence is a very dangerous precedent if it's not defined narrowly. And especially if things aren't contextualized and clarified with accurate historical perspective and understandings of systemic power. I think we would be better off with even creating a truth commission or a committee of people of the most impacted and marginalized due to the historical precedent of hate crimes here in the United States to offer clarification and definition of what constitutes hate crime within that historical context. And it would allow things to be narrowly drafted enough so that it doesn't have an unintended impact of harm on those who have been historically marginalized, most especially Black, Latinx, migrant, folks who experience gender discrimination, folks who experience historical oppression and violence and harm in the United States. So just a few other points. with the ambiguity of this bill and having been involved in a lot of organizing and activism myself, standing in solidarity with Palestine, I'm afraid of this bill being a misrepresentation of what Judaism and anti-Zionism is. I'm not Jewish, but as you've heard from Jewish comrades already, the conflation of Zionism with terrorism misrepresents the issue and endangers activists who are protesting harmful ideology that is has nothing to do with what Judaism is.
Thank you, ma'am. That's the bell. I know, unfortunately, the bell doesn't come through on the
So, for
on the
sure. Thank you
thing.
so much for your time. Yeah, I submitted written testimony, so if you wanted to know more about what I had to say, it's all in there. So thank you so much.
Thank you. Questions or comments? Seeing none, appreciate you being with us this morning. Liza Andrews?
Good morning, Representative Staffstrom, Senator Winfield, Senator Kissel, Representative Fishbein, members of the committee. My name is Liza Andrews. I'm the Vice President of Government and Public Relations for Connecticut Coalition Against Domestic Violence. You have my written remarks. I'll just hit some high points on House Bill 7139, specifically with sections 13 and 14 as they relate to electronic transmission of service of process. So section 13 is new language and section 14 is some existing language within the family violence restraining order statute. As you know, Connecticut receives approximately $2 million annually through the U.S. Department of Justice STOP grant program. In order to receive that money, the state must certify that its laws and policies do not allow victims to bear the costs associated with the filing, issuance, or service of restraining orders. So section 13 establishes fees for electronic transmission and printing, but does carve that out in lines 516, but then some language added in section 14, lines 551 through 552 is somewhat vague, potentially leaving the door open for those costs not to be borne by the judicial branch, who currently pays for all fees associated with service of restraining orders, but potentially leaving that open for survivors. So we just think that could be cleared up by saying that those fees for electronic transmission and printing are prohibited according to section 13 of the Act. Section 13 also states that marshals are not required to accept process electronically, but they may elect to do so from an attorney at law or public agency only. So in the restraining order statute, it says that marshals shall accept service in electronic format presented that way. And then obviously the restraining order statute also requires the applicant or the victim to cause service. They're rarely represented by an attorney. So again, I just think there are some contradictory pieces that just need to be cleaned up. We support electronic service. We want it to be clear for both the marshals and the victims what they need to do to get their restraining order served. So happy to work with the proponents of the bill on that. And with that, I'll answer any questions.
Great. Rep. Fishman?
Thank you, Mr. Chairman. Morning, Les.
Good morning.
Can you just walk me step by step through what you were just saying? Well, first of all, it's not electronic service. It's getting the documents from the court to the marshal for service,
Yes.
right? I just want to be clear there. And you recognize that the fees are exempted. I think it's in section 12. But then you said there's a problem in section 13?
So I read it in lines 516, which I believe is section 13. And that's the carve out in the new language around electronics transmission and printing. A carve out for any fees associated with restraining orders.
Okay,
Right.
that clearly says that.
Correct.
And then where do we get the problem?
So when you go look at lines 551 through 552, so the cost of service is for restraining orders is currently the responsibility of the judicial branch. And then it just says accept fees for electronics transmission and printing. So I think if we could just say accept fees because they are prohibited by section 13, not leave the door open for a marshal to maybe be confused and say, I can charge that $1 per page fee to the victim.
Okay, because it says accept fees for electronic transmission and printing pursuant to section 13. Section 13 does exempt them. So
I agree.
I'm just trying to figure out what would you suggest as a change? It seems clear to me. I just,
Yeah. Well, so we didn't have clarity in our office, right? Multiple people read it different ways. So I think accept fees for electronic transmission and printing, which are prohibited pursuant to section 13 of the
okay,
Act.
what if I suggest this? Accept fees as authorized,
Sure,
right?
correct,
And
because
this
they're
is
not
true.
authorized by section 13. Correct.
Agreed.
Sure.
Any other problem with the language before us?
No, again, just want to make sure, because if you then look up at lines 547 through 549, which is just saying that the electronic transmission has to be subject to the provisions applicable to attorneys at law or public agencies per section 13. Just again, want to make sure that we're not changing that applicants themselves can cause the notice of hearing, right? Because that's what it says at the very top in line 541.
Yeah.
Yeah.
So logistically, because I know there's language in here about the papers have to be clear, have to be complete, stuff like that. An individual pro se party would still be constrained by those requirements as well.
Yeah.
So you would just have that particular section, those lines expanded to pro se parties?
It's what I suggested in my testimony. If there's some additional language we need to put in the restraining order statute to again make it clear to the applicant what they need to do and that they have to do it in order to do this electronic transmission, we're fine with that. We just don't want a situation where there's anything that would lead the applicant to have an attorney to do electronic transmission. So we've had electronic transmission for restraining orders since the pandemic. We codified it, as you can see, in the restraining order statute in 2021. I think it's worked probably okay. I think in my conversations actually with the Marshals Association, who will be up a little later, that it's a very small fraction of restraining orders. They still largely come through the court, get printed out at court and handed in paper form to the marshal, usually the marshal of the day who's at the courthouse. But we just want to make sure again that we don't do anything to this restraining order statute to have the victim bear a cost to file or serve a restraining order. That's all.
Yeah, no, understood. I mean, it's a very time sensitive situation.
Mhm.
And in your experience since this has started, have there been problems with that the transmission, the time sensitive nature?
In recent years, not that I've been made aware of. At the very start during the pandemic, of course, there were a lot of bumps in the road, but I think it's gotten pretty smooth since then.
Okay. Well, thank you. Thank you, Mr. Chairman.
Thank you. Yeah, Liza, I definitely would suggest you speak to the Marshals Association because I don't think, Brian's sitting back there.
Yep.
Because I don't think, certainly the intent of this language, as I understand it, is not to deal with the restraining order or change the restraining order process or the like. What this is really getting at is frankly more in a practice like mine on
Yeah.
the civil side,
Yep.
where I'm in Bridgeport and I need to serve a complaint in New London. And so rather than me having to FedEx it to a marshal in New London, I
Sure.
can email the summons and complaint to the email to the marshal in New London, and he can
Yeah.
print it out and serve it and the like, which is not permitted. So I think this is a long overdue
Mhm.
modernization, frankly, that we need to get done this year. So I would
Yeah.
suggest you work through the language for them.
Oh, for sure. I didn't think there was any ill intent here. I thought it was just could be clarified.
All right. Seeing no further questions, appreciate you being with us.
Thank you.
Eamon Ormseth.
Yeah, that's me. Can you hear me?
Go ahead, sir.
Dear members of the Joint Judiciary Committee, my name is Eamon Ormseth. I live in Hartford. I'm a local peace builder and humanitarian advocate. I'm testifying in opposition to Governor's Bill 6872, an act revising and consolidating the hate crime statutes, because without some changes, the proposed bill would cause more problems than it solves. It would allow for an increased police presence among marginalized communities and further the repression of organizers and activists across the state. I'm concerned that the bill's vague language around religious objects and symbols will infringe on freedom of speech. The bill does not clearly define what a religious object or symbol is, and the fact that political movements the world over use religious symbols in their branding and presentation means that opposing a hateful political movement that uses a religious symbol could be penalized under this bill. For example, if far-right extremists decide to start using the Christian cross as a symbol of advancing Trump's far-right agenda, and folks take the Christian cross and some of this political branding and throw it in a trash can to express their opposition to Trump's agenda. As I read this bill, such an act could be penalized, partially because the bill defines desecrate as meaning to mar, deface, or damage as a demonstration of irreverence or contempt. And I can say now as a citizen that I do have irreverence for a lot of Trump's agenda. And so for these reasons, and for some of the previously stated reasons that this bill does not just revise and consolidate, it expands, including the introduction of mandatory minimums, I think this bill will chill freedom of speech and freedom of worship. And as a peace builder, I do want peace. And of course, like everyone here, I don't want hate crimes to be committed. But my fear is that bringing the state into people's political expression will only escalate tensions instead of allowing folks like me and others to do the hard work of having dialogue and sitting down with people who we disagree with. So for these reasons, I urge you to vote no on Governor's Bill 6872. It risks fostering a dangerous precedent by protecting political ideology, and it also has the potential to increase police repression. Thank you very much for your time.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none, thank you very much for joining us today. Jillian Davey. Jillian Davey. Gary Jones.
My name is Gary Jones. I am the director of the Jewish Community Relations Council of the United Jewish Federation of Stamford, Darien, and New Canaan. I have also been asked to deliver this testimony on behalf of the Jewish Federation of Greater Hartford. Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and committee members. Thank you for the opportunity to provide testimony in support of House Bill number 6872, an act revising and consolidating hate crime statutes. We strongly endorse the bill as it substantially improves our current hate crimes laws. Our state can be proud of the fact that Connecticut was one of the first states to adopt laws that added additional punishments for crimes that were committed because of hatred or bias based on race, religion, and other designated groups. Over time, new hate crimes laws have often been added to different parts of the penal code, which sometimes resulted in confusing and potentially inconsistent treatment of hate crimes. From the procedural perspective, this bill would place all hate crimes in a single statutory section in the penal code. In addition, it would clean up inconsistencies in the law and provide a single, clearer standard of what constitutes a hate crime, resulting from criminal actions intentionally committed based on the protected class of the victims. This bill recognizes that crimes targeting people for their gender identity or expression should also be considered as potential hate crimes. In addition, our current laws do not allow perpetrators of some of Connecticut's more serious crimes to be charged with violation of our hate crimes laws. This bill would correct that limitation. Our laws, excuse me, our laws that impose additional punishment for hate crimes are not clearly labeled as hate crimes. Additional criminal penalties may be available, but the purpose of these penalties is not clearly stated. This bill, number 6827, will ensure that hate crimes laws will be clearly labeled as such. One of the principal purposes of hate crimes laws is to make it crystal clear that hate crimes hurt entire communities of people and not just the direct victims. The adoption of this proposed bill will deliver that message loudly and clearly and confirm that such acts are unacceptable in a civilized society. Please pass this bill as further confirmation that Connecticut will always stand with the victims of hate. Thank you.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? Senator Kissel. Oh, you're just waving. Sorry. I don't see any, so thank you very much for joining us today.
Thank you very much.
Sasha Kaufman. I'm still going to run through the names. Basil Al-Najjar. Basil Al-Najjar. Elizabeth Tang. Elizabeth Tang. Adam Bomash.
Dear members of the Joint Judiciary Committee, my name is Adam Bolmash. I am from Farmington. I'm a member of both the Hartford Jewish Organizing Collective and CT Social Workers for Palestine. I am a Jewish man, and over 60 members of my family were murdered in the Holocaust. I am testifying today in opposition to Governor's Bill 6872, an act revising and consolidating the hate crime statutes. Barring significant amendments, the proposed bill would have a negative impact on the problem it claims to be addressing. It would allow for an increased police presence among marginalized communities and will be utilized to repress organizers and activists across the state. What's more, hate crimes legislation already exists in this country and state, and they are in no need of expansion. This dangerous and undemocratic bill, with its vague language, has the potential to suppress protests and criminalize dissent. Activists and organizers advocating for social justice will face increased legal retaliation under the guise of hate crimes, disproportionately targeting those who challenge systemic oppression. Hate crime laws were originally designed to protect historically marginalized communities. Expanding these protections to political ideology, occupation, and genocide dilutes their purpose, undermining the intent behind civil rights protections and shifting focus away from communities that actually face systemic discrimination, such as Palestinians. This bill will create a chilling effect on political activism and free expression by allowing those in power to claim persecution when criticized. It opens the door for bad faith legal challenges against those advocating for change, stifling democratic discourse and grassroots movements. Case in point, I see someone from the Anti-Defamation League is here today, a so-called anti-hate organization that defended Elon Musk's Nazi salute as a quote-unquote awkward hand gesture. I urge you to ignore their testimony and to listen to real Jews of conscience like myself. The people of the ADL have no idea what a hate crime is, and Nazi apologists have no right whatsoever to speak on the matter of hate crimes. The ADL has openly admitted to labeling any pro-Palestine activism, including those organized by Jews of conscience, as anti-Semitic simply for being pro-Palestine. These are exactly the kinds of people who would abuse this hate crimes legislation. The ADL does not speak or act in good faith, and they have betrayed the American Jewish community in their unwavering support of the fascist Trump and the genocidal state of Israel. Anyone from such an undemocratic, pro-genocide, and pro-Nazi organization should be ashamed to call themselves Jews. And I fear for the new ways they would use this hate crimes legislation as a weapon to subvert our democratic rights under this tyrannical administration. Already, pro-Palestine activists like Mahmoud Khalil of Columbia University are facing arrest and deportation for their activism. I do not understand why anyone who's supposedly a Democrat would seek to give the Trump administration even more weapons. I urge you to vote no on Governor's Bill 6872 and to protect our democratic rights. Thank you for your time. Thank you.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none, I will thank you very much for joining us today. We're going to go next to Elizabeth Tang. I'll just say this. Everyone has a right to testify. We do believe in free speech. The members of the committee will weigh individually the testimony that is before them. We understand that people might have a perspective on individuals' testimony and whether they should be paid attention to or not, but we will weigh those testimonies individually. Elizabeth Tang.
Thank you, and I apologize for not being ready earlier. I was trying to join as a panelist while I was, anyways, thank you. Good afternoon, Mr. Co-Chairs, Madam Co-Vice Chairs, and the Joint Committee. I'm Elizabeth Tang from the National Women's Law Center. I'm a civil rights attorney and a sexual assault survivor, and I'm here in strong support of HB 7134, an act concerning enhanced protections available under the state's anti-SLAPP statute. Here in Connecticut, over 1 million residents will be victims of sexual violence in their lifetime, but most of them will never come forward. And one of the biggest reasons that survivors stay silent is the very real fear of retaliation. 1 in 5 student survivors are targeted or threatened with a defamation lawsuit. Defamation suits are the 3rd most common form of retaliation for survivors in the workplace. And abusers do not necessarily expect to win these frivolous cases, but they know that their victims must still incur immense financial and psychological costs to defend against these baseless lawsuits to the very end. We're talking 5, 6, 7 figures to defend these cases. This is how many victims of gender-based violence are coerced into staying silent or withdrawing their claims. And I've seen many of these terrible cases at the National Women's Law Center. In 2023, I co-authored a toolkit with survivors who have been sued for defamation because they spoke out on how they can fight back. I have also submitted numerous amicus briefs to state courts, to Connecticut, DC, Illinois, Massachusetts, and New York in support of survivors who were sued for defamation after reporting that they were sexually assaulted. HB 7134 is critical to closing this gap, to ensuring that abusers can no longer weaponize the Connecticut courts against their victims. And importantly, HB 7134 ensures fairness to every person. This bill ensures that Connecticut's existing anti-SLAPP law, which already protects statements about health or safety and community well-being, is properly applied to statements alleging sexual assault. I know that we can all agree that sexual assault is undeniably an issue of health, safety, and community well-being and deserves to be covered by Connecticut's anti-SLAPP law. Under this bill, Connecticut survivors who make good faith reports of sexual assault, that is, quote, without malice, will be protected from retaliatory lawsuits and would receive attorney's fees and court costs. This ensures that survivors can speak freely about their assault in the first place without fear of retaliation, just like everyone else who reports other types of misconduct and who are already protected under Connecticut's anti-SLAPP law. The bill is also fair to those who are accused of sexual assault. If a plaintiff can show with particularity that there is probable cause that they were in fact falsely accused, their lawsuit can still proceed, just like any other person who is reported for misconduct under Connecticut's anti-SLAPP law. So in other words, HB 7134 treats all parties fairly, and those who claim that it is somehow unfair are simply asking you to carve out sexual assault survivors from Connecticut's protections and to give special rights to accused rapists and abusers. HB 7134 is also nothing new. In the past few years, states like California, New York, Rhode Island, Tennessee, Vermont, and Washington State all have passed laws to explicitly protect survivors from being targeted by retaliatory defamation lawsuits and other abusive lawsuits. I hope Connecticut can join them. For all of these reasons, I ask the committee to issue a favorable report on HB 7134. Thank you.
Thank you. Comment or question from members of the committee? Representative Fishbach.
Thank you, Mr. Chairman. Ma'am, I know you're off the list, or at least in out of order. What was your name again?
My name is Elizabeth Tang. I'm from the National Women's Law Center. I was the one supposed to speak before Mr. Adam Balosh. I was just struggling with my getting promoted from attendee to panelist.
Okay. And have you been personally involved in a lawsuit in Connecticut involving what's before us here today?
The National Women's Law Center did join an amicus brief in Connecticut. in support of a survivor who was sued for defamation. Yes, that's true.
Okay, so can you tell me something about that case? So somebody getting sued for defamation, I assume that someone made a public statement claiming that they had been sexually assaulted. Is that the underlying of that case?
Yes.
And that individual who made the public statement was then sued for defamation here in Connecticut.
Correct. In that particular case, it was a student who had reported to her school's Title IX office that her classmate had sexually assaulted her. And because she made this report to her Title IX office, which it is fully her right to do, and really the only way that she can receive any sort of help from her school to protect her civil rights, her right to have equal access to education. As a result of that, she was sued for defamation. And so, as I mentioned in my testimony, these sort of retaliatory lawsuits then act as a silencing mechanism, weaponizing the courts against survivors who want to just assert their rights and seek justice, going through proper channels, such as through their school's Title IX office, such as through their workplace's HR office, such as filing a complaint, perhaps with an agency or other, proper channels I've seen in other states. Filing police reports to ask for a protection order can get you sued for defamation. And so these retaliatory suits then create a mechanism by which survivors are silenced and barred from the very mechanisms that the law has created to help them.
Okay, I don't think any of that was responsive to what I was asking you about, but I thank you for that. So this one case in Connecticut involved a student complaining about a sexual assault, which I think one should complain about a sexual assault. The alleged victim or the alleged perpetrator then sued the victim for defamation. And what was the outcome of that case?
The defamation suit?
Yes.
I would have to pull up my notes. I don't have all of the information fully in front of me. I don't want to misspeak. If you want to give me a moment, I can try to pull it up. I can also answer
We're sitting in
afterwards.
the legislature and you're advocating for us to change the law, and I'm just trying to figure out, so taking this a step further, what this would allow the procedure to do is to permit the defendant, so this is the perpetrator, would be able to bring a motion to, no, I'm sorry, I get that juxtaposed.
The other way around.
The alleged victim would be able to bring a special motion to dismiss to get rid of the defamation case. That's what you're asking for here.
Yes, because under Connecticut law, the anti-SLAPP statute protects statements that are made about health, safety, or community well-being from being subject to defamation liability or other forms of abusive litigation, where the speaker can prove that they were speaking about health, safety, or community well-being, as well as other categories. But what I've seen across the country is that many times courts will say, well, sexual assault is not actually an issue of health, safety, or community well-being, and it's actually a private matter. And this goes to the sexist nature of the history of how sexual assault and domestic violence have been viewed as private matters as opposed to public matters. And so what this bill would do is to ensure that that is recognized and to make sure that people who speak out about sexual assault are treated in the same manner as people who speak out about other types of misconduct. As I said in my testimony, the bill is not seeking to create some sort of absolute bar for people accused of sexual assault from ever bringing defamation claims. It's just seeking to treat people who are accused of sexual assault and people who speak out about sexual assault the same way that other people are treated under Connecticut law when they report misconduct or they are accused of misconduct. And so if somebody who is accused of sexual assault can show that there is probable cause that they were falsely accused, they can still proceed with their lawsuit.
Got it. So should this legislature pass this legislation, we have a lawsuit claiming sexual act we have a lawsuit claiming defamation for reporting sexual act. How is the court to dispose of that under this process?
If the bill were to pass, then the court would consider a survivor's anti-SLAPP motion when they are sued for defamation and consider it under the same standards that are applied to other forms of participation in public life, such as speaking about health, safety, and community well-being.
Okay, but at the end of the day, wouldn't the court have to analyze whether or not the statement was true or not?
The court would have to conduct the same analysis as for other anti-SLAPP motions. And so the court would consider as a first stage, was this statement made on an issue of health or safety or community well-being, or with the passage of the bill about sexual assault, harassment, or other discrimination? And if that's the case, then the anti-SLAPP motion can be considered. And then the plaintiff has an opportunity also to say, no, well, there is probable cause. I can plead with particularity that there's probable cause that I was in fact falsely accused, and I can prevail on the elements of my claim. And then the defendant can say, no, that's not the case. They have not pled with particularity that there is probable cause that they can can prevail on the elements of their claim. And then it's up to the judge to decide whether or not the defamation suit has been pled with particularity, whether there is probable cause. So it's up to the judge to make that decision. And so what this bill is doing is just ensuring that those who report sexual assault and then are sued for defamation are entitled to have that process in the first place, rather than being shut out and being presumed that sexual assault, for example, is not a matter of health or safety or community well-being, and therefore not entitled to anti-SLAPP consideration at all.
So the anti-SLAPP statute as it presently exists, does it extend to defamation cases?
Yes, it extends to any case that is, it could be defamation, it could be intentional infliction of emotional distress, it could be tortious interference with business relations. There are many types, and I'm just naming a few, there are many others, many types of claims that are commonly brought against people who speak out about misconduct. There are folks who, for example, could protest a pipeline construction and be slapped with a lawsuit by, for example, oil and gas corporation. And so there are many different ways that this shows up. It could be a journalist reporting on a politician's corruption and being sued for defamation. So a whistleblower at a company calling out the company's abuses, being sued. There are many different types of claims. Defamation claims are just one of many types.
Okay, but the free speech protections that are looked to be protected here through the existing anti-SLAPP statute don't extend to defamation.
I'm sorry, I don't think that's correct. Can you repeat that again? I didn't follow your question.
The traditional anti-SLAPP situation is the individual, well, the whistleblower, the person that finds out that things are happening badly in their community and goes to the press or something like that. And an action is brought to stop those statements, an injunctive action, let's say. In response to that, the individual can bring a special motion to dismiss to get rid of that action. That's the traditional freedom of speech that's protected by SLAPP. I'm just having a lot of problems extending this when in a defamation case, truth is a bar. So if one complains about a sexual assault and then they are sued because they complained about the sexual assault, the court is naturally going to get into whether or not there wasn't a sexual assault. And if there wasn't, then more than likely it is defamation. So extending it here, it really seems like a stretch,
So
but
I just want to correct the misunderstanding that I believe I'm hearing from you. Defamation suits are bread and butter in terms of the type of claims that are that anti-SLAPP motions are applied to across the country. This is not something new that is coming up just because we're talking about sexual assault. Anti-SLAPP motions are used commonly across the country for decades in response to defamation suits, whether that is for in response to speaking about sexual assault or response to speaking about other types of misconduct. That is very commonly understood, and I assure you that the Connecticut anti-SLAPP statute that exists currently on the books already applies to defamation claims.
can you give me the side of the case that you mentioned before? What's the name of that case?
The case that National Women's Law Center has weighed in on before.
The one case in Connecticut that you said may touch on this issue.
Kahn versus Yale is the case that we weighed in on.
KAHN?
Yes.
Okay, thank you. Thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members of the committee? Comment or question from other members of the committee? Seeing none, thank you very much for joining us today.
Thank you.
Leora Madison.
Hello, Senate Judiciary Committee. My name's Leora Madison. I live in Southbury, Connecticut, and I am unfortunately here to testify against SB 6872. As a disabled Jewish woman, I am very concerned about hate crimes. However, I have to echo the concerns brought up by other people here, considering the well-known problems of racism and other forms of discrimination in the police force. Is using the police as a way to prevent hate crimes going to be particularly effective, considering the police commit some of the hate crimes? And in other cases, the most marginalized people might be reluctant to go to the police when they experience hate crimes for fear of experiencing discrimination. I also echo the concerns that vague language in hate crimes laws could be exploited to be weaponized, that supposedly to protect some marginalized groups could be weaponized against other marginalized groups, such as but not limited to Palestinians, transgender women, or even Black people protesting discrimination. The laws could be weaponized to consider them being anti-right. However, others can speak about that more knowledgeably than me, but I could speak most knowledgeably about all my concerns about the section on page 10, which creates greater consequences for committing a hate crime wearing a mask. I am concerned about this because I'm someone who lives with immunocompromised family. My mother is immunocompromised. If I bring COVID or flu home to my mother, it could kill her. Additionally, COVID is unfortunately still around, and rates of long COVID are not that low. There were studies at the beginning of the pandemic that estimated between 10 and even as high as 50% of people who got COVID could get long COVID, depending on different definitions of it. After the vaccines came out, they did reduce your risk of getting long COVID, but only by different studies said by different amounts, but it seemed to average by around half. So that would mean like a 5 to 25% risk of getting long COVID. And as someone who's already disabled, that risk is too high for me. So I also wear a mask to protect myself when I'm out and about too. And I'm concerned laws that create greater penalties for crimes committed wearing a mask could increase stigma towards people who wear masks and lead to discrimination against us, or even ironically, crimes committed violence and harassment against us for wearing a mask, which I would consider a form of hate crime based on disability.
Thank you.
For example,
Excuse me.
there was a
Yeah,
man
excuse
in
me.
New Jersey was left permanently blind after being
Excuse
attacked for wearing
me.
a mask in
Your time
September
has elapsed, so
2023.
we're going to see if there are questions or comments from members of the committee. Question or comment from members of the committee? Question or comment from members of the committee? We don't have any, so I want to thank you very much for joining us today to provide us with your testimony. Next, we will hear from Adam Antar.
Assalamu alaikum. This is in regards to 6872. I'm a board member of the Muslim Justice Center, founder of the Bristol Anti-Racism Brigade, and a decades-long activist against white supremacy. I've been physically attacked for my skin color, for being Muslim, and even for being perceived as Jewish. I've spent years trying to make sure marginalized communities are strong and safe. This bill does not protect marginalized communities, but it has and will be used to protect white supremacy. Members of the Muslim community were asked to provide input on this bill. We discussed the draft with a local racial justice heroine, Corinne Prescott, and put together a number of recommendations and concerns. None of those recommendations were added, nor were any of our concerns addressed. It begs the question, who is this legislation meant to protect? We need not speculate. Connecticut's history has demonstrated who this bill is meant to protect: white supremacist institutions. When Representative Khan was attacked in what was demonstrably a physical and sexual assault based on religious animus, the state refused to bring hate crime charges. When the New Britain Masjid received a shooting threat based on our religion, and the perpetrator had a firearm positioned in a window facing the masjid's parking lot where children play, the police not only refused hate crime charges, but further refused to meet with community members to discuss our concerns. However, when a dark-skinned man is accused of throwing paint on a building profiting from the genocide of brown people, the state immediately pursues hate crime charges. A building owned by a white man is more protected by these hate crime laws than any of the black or brown people, not property, who have actually faced violence precipitated by bigotry. It could not be more abundantly clear that this bill will harm, not protect us. This bill uses the veil of anti-discriminatory language to further entrench discrimination against black and brown people, to further criminalize us, to further shut down dissent and freedom of speech. This bill will ensure people in Representative Khan's position would never be protected by hate crime laws. These are not abstract hypotheticals. This is how hate crime laws have and will be used. This bill does not address any of these concerns. This bill does not address concerns around the usage of religious symbols being used as political symbols. The swastika is one of the world's oldest religious symbols, but only a fool would believe a swastika in today's atmosphere was anything but vile anti-Semitism. It has ceased to be a religious symbol and is instead the symbol of a genocidal state. There must be a clause to ensure political opinion under the guise of faith does not receive such protections. Are you prepared to criminalize the burning of an ISIS flag simply because it says, La ilaha illallah? If this bill were passed today in order to be applied equally, a constitutional requirement, that would be the natural outcome. The entirety of the hate crime scheme in Connecticut has been used to assault freedom of speech and black and brown people. This must be seriously reconsidered and altered to actually protect marginalized community, not political ideology. The Trump administration is currently disappearing people for political opinions. We cannot allow that to be codified in Connecticut. If you want to protect marginalized communities, talk to marginalized communities. It seems that this well-intentioned bill serves a political agenda rather than the safety of marginalized communities. Thank you.
Thank you. Comment, question from members of the committee. Comment, question from members of the committee. There are none. Thank you very much for joining us this afternoon to provide your testimony. Mark Conway. Senator Berthel, since you're with him, when you both come up, both identify yourselves, please.
Good afternoon, Chairman Winfield, Chairman Strapstam, Ranking Member Kissel, Ranking Member Fishbein, and all honorable members of the Judiciary Committee. I am Senator Eric Berthel. I'm here to testify in support of Senate Bill 1439, an act concerning the definition of child sexual abuse material. I thank the committee for your consideration and hearing this bill today. I'm joined by Watertown Police Department Detective Mark Conway, who is also a member of the statewide Internet Crimes Against Children Task Force. The general purpose of the bill is to align the Connecticut definition of child sexual abuse material with the federal definition of child pornography. I am by no means an expert on this subject, but Detective Conway is, and he is the person who asked me to propose the bill before you. Mr. Chair, with your indulgence, I would like to yield my time to Detective Conway for his testimony.
Thank you. Thank you, Senator Berthel, and this committee for your work on this bill concerning the definition of child sexual abuse material, also known as CSAM. I have been investigating child sexual abuse and exploitation for the past 16 years. I have interviewed countless offenders in crimes against children, which has given me insight into their methods and motivations. I routinely examine devices recovered from offenders and have viewed hundreds of thousands of depictions of CSAM. I have reviewed thousands of messages between offenders, buying, selling, and trading CSAM, and worse, thousands of messages of offenders communicating with children, grooming them, extorting them, manipulating them into sharing CSAM, and/or meeting with them in real life and abusing them. Our current definition of CSAM is, quote, of a person under 16 years old. With the rise of technology, CSAM is being created through AI of children, which are not statutory people. In most instances, you cannot tell if it's a real kid or not. The fact that it may not be a real kid doesn't make it any better or any safer. I believe that CSAM is the fuel that drives the offenders to further sexually exploit or abuse children. CSAM and child abuse transcends all boundaries, affecting children regardless of race, gender, or socioeconomic class. As we see in the news, the offenders come from every corner of society. It is truly a crime that crosses state line and country borders. The proposed language includes a person under 16 or a person who appears indistinguishable from a person under 16. Indistinguishable would bring us in line with the longstanding federal definition of child pornography and in line with many other states addressing AI kids legislatively.
Oh, okay, great. Senator Kissel.
Thank you very much, Chairman Winfield. Senator Berthel, always great to see you before
you,
the
Senator.
Judiciary Committee, your old committee, as you brought me up to speed this morning. Detective Conway?
Yes, sir.
Is that the proper moniker?
Yes, sir.
Okay. First of all, what's the problem in Connecticut and how will this bill remedy that problem?
So the problem in Connecticut is that we are seeing a rise of AI children. We have a lot more images and videos and depictions being reported. And, you know, technically they're not illegal. They're still being used as fuel to facilitate offenders in their advancement of sexual exploitation of children. But those images, as real as they are, and they are extremely real, are not illegal at this point.
So with the advent of artificial intelligence, it's really remarkable seeing how fast it's developed. And people that are, you know, movie stars or national icons. I think Senator Berthel brought me up to speed on a famous singer we have out there who was shown in rather risque mode at maybe a National Football League game, and one can guess who that might be. But is it the situation right now, if someone used one of these images that look like a real person, like Taylor Swift, but a minor under 16 years old, that the states, that let's say there's an arrest. So what you're saying is that the state's attorney would have a difficult time proving that the image was that of a person if the defendant raised the defense that no, this is an artificially created image that looks remarkably exactly like a human being, but is not.
So we currently have laws on the books protecting adults from that because Taylor Swift is a person. But when it's a 5-year-old created through AI, not to look like Taylor Swift, just to look like any other 5-year-old, that is where we're running into issues legislatively.
So would this change in the statutes actually make it a crime to have an image that looks exactly like a minor, even though there was no human being
Correct.
harmed?
Correct. So AI has to start somewhere, and it starts with depictions of real kids. from whatever data set it's getting, whatever data set the AI is using. So it is going out and getting images of real kids and morphing all of those images into one to create a new image, which, even though it's made up of many real kids, is not an actual person.
And so you're saying that this would bring us in comportment with the federal law and other states? What's the
Correct.
closest state to us, if you're aware?
I don't know closest to us, but there are over 30 states that are addressing this or have addressed this already. The majority of them are using the term indistinguishable from a real person, and that is the longstanding federal definition of child pornography.
Okay, and the only reason I say closest to us is a lot of times when we're dealing with bills, people like to reference, oh, this has been done in Massachusetts, New York, and the Northeast.
I
But-
can get that information for you, but I don't know offhand
Okay, and
geographically.
with your indulgence, Mr. Chair, just two more quick questions. You said that you were working on a task force or a study group or a participation in a group. Are you speaking or testifying on their behalf, or is this your own behalf?
This is on my own behalf, but they support this.
And do you know if any of these other, either the federal law or the other state laws have been challenged in court and sustained?
This
Or upheld as far as being constitutional?
indistinguishable has not been, it has been challenged when it was written. The original intent of the law was struck down because it was very broad. And if you have an adult who is clearly an adult and dresses up to look like a schoolgirl, to look like a child, the initial law was struck down because that person would have been brought under that umbrella. So it has been modified, I believe, in 2003 on the federal level. And that has not been challenged since, I believe, 2003.
Okay, I'm guessing in 22 years, there would have been a challenge
Yes.
or it would have been struck down.
Yes.
So Senator Berthel, thank you so much for coming to testify, and Detective Conway, thank you for your advocacy. Thank you, Mr. Chair.
Thank you.
Thank you. Representative Fishbein.
Thank you, Mr. Chairman. Thank you for coming here today.
Thank you.
Why 16? Why is that the age that's selected here?
That is what Connecticut has been using for the definition of child pornography. There are other relevant statutes that are 17 and under in Connecticut. Some obscenity in Connecticut is 17 and under, but the old child pornography and the current child sex abuse material is under 16.
Okay.
Federal law is under 18.
Okay. How does one tell? I mean, I don't know. Do you have special training as to whether or not to ascertain? So this appears indistinguishable from a person under 16 years of age. So that means,
So
I don't, what is the training that an officer receives to be able to ascertain that?
So the indistinguishable is more from a real person or a fake person. If the AI child is indistinguishable from a real person, if we can't tell if that is a real kid or not a real kid, that would fall into this statute. So if you're referring to the age, we are under 16 years old. And it is generally the investigator's determination who is under 16 years old. And then that gets brought to our prosecutors who concur. Sometimes we identify the victim and we know that they're 12 years old. Other times we just go by our training and experience. And yes, we do have certain experiences in determining ages. But another distinction that I want to make is the 14 and 15-year-olds that are questionable and we don't know their identity, that is not the typical victim that we are seeing in these videos. They are 8 years old, 5 years old, 3 years old, infants. So I think generally people believe that child sexual abuse material is of like a difficult to tell how old they are. It's very simple to say that person is under 5 years old or that person is under 10 years old. If we have a person who looks like they're 15 and we don't know who this kid is, then they could be 16. And we typically would not count that as a chargeable depiction against that person.
So, what goes into making an AI image?
So a lot of times when our offenders are communicating with other people who are selling child pornography, they are very specific on what they want. They may want a 5 to 7 year old and they'll ask, hey, I want a 5 to 7 year old. I want a kid with blue eyes. I want this. I want very specific things. When they are talking to kids themselves, they have specific demands. They want this kid to wear certain clothes, or they want the camera in a certain angle. So they're very descriptive in what they want. So when you're making an AI video image depiction, the person who is creating that inputs descriptors. I want a 5-year-old with blue eyes. So they tell the AI what they want to see, and the AI generates that. Now, one thing is if you go to a mainstream app or website, or Google and ask them to create AI child pornography, they are not going to do that because they're mainstream. There are safeguards set up, but there are plenty of other unregulated applications or pieces of software to make those images for you.
So I took it from your answer before that in order to prosecute, you need to identify an individual that this is looking to emulate. Is that fair? Or can one just generate a video through AI of an unidentified 4-year-old engaged in some sort of act and be prosecuted under this language?
So the unidentified 4-year-old would generally be prosecuted as a 4-year-old if we cannot tell. So with AI, there are issues with it. Somebody may generate an AI image and that it just looks fake. We know it's fake. We know that's not a real person. That image would be distinguishable from a real person. We would not count that against them. We would not be able to charge, the prosecutors would not be able to charge for that image.
Why not? I mean, I don't know, maybe this building thinks that that's appropriate activity. But if I am selling video of what is clearly a 4-year-old engaged in some sexual act to someone else, why isn't that illegal?
That's the way
even if they're not identified, right? Because certainly we don't want that. I don't want it.
Right. So when
that gratification over the image, no matter whether that person exists or not.
When our statutes were written, AI was not a thing. So I think the authors just wrote of a person under 16. Well, now it is a thing.
So if this language were to pass, would that possessing that video, even though you can't identify the 4-year-old, would that be illegal?
Yes, the burden would be on the prosecutors to tell a jury. It's up to the jury to make the determination how old the unidentified person is. And the standard in this statute is an ordinary person. If an ordinary person would see this image and determine that that is a 5-year-old kid, then that would be their determination.
Okay, so the answer is yes.
Yes.
You could prosecute for possession of that.
The burden
that
would be
video.
on the state.
No,
to-
I understand.
Yes.
We
But
get the
yes,
burdens, right? But
yes.
people get arrested, they get prosecuted, many times they plea out, never gets to a jury. Right?
Correct.
So I also wanted to ask you about in line 92. We extend this to drawings, cartoons, sculptures, and painting. I mean, I guess the problem, well, the good thing is you have to be engaging in sexually explicit conduct.
Well, no, drawings, and we see a lot of drawings, anime. There are video games of realistic players sexually abusing kids, and it's pretty realistic. Those are distinguishable from real kids. So those would not be criminalized under these statutes
Under our present statute.
or the proposed.
Why not? Why hasn't somebody gone to that length?
I don't believe anybody has. I don't have that answer.
So it's public policy appropriate in the state of Connecticut that one can be in possession of a video game
Yes.
that depicts children of the age of, let's say, 5 engaging in sexual acts, and that is okay, that under our law.
Under our law, it is not a person or it is not indistinguishable. So yes, it would not be criminalized.
And even if this law passed,
That
it
would
would
still,
still not be criminalized.
correct.
Well, in 1440, because I believe you're here on that also. You're on 1439, 1440, which is the dissemination of intimate images. Are you here on that also?
I am not.
Okay, that's fine. Hopefully someone, so, well, thank you.
I may be.
I would
able
hope that someday we get this whole thing under control, but thank you, Mr. Chairman.
Thank you. I have a question because I'm not clear on your answer to Representative Fishbein. So if the image that someone had was a drawing, you were saying it's not covered.
It is
But
not.
under the current law, I believe mechanical production is included. And
So-
a drawing is a mechanical production.
So
Why-
under the current Connecticut statute, it is computer generated.
I mean, when we talk about child sexual abuse material as currently defined and you're now adding to, it talks about the means of production, the production, I'm not going to read the whole thing, but the production of such visual depiction, I'm sorry, I have to go back. Let's see, child sexual abuse material means any visual depiction, including any photograph, film, videotape, picture, or computer-generated image or picture, whether made or produced by electronic, digital, mechanical, or other means. So
Of a person. So that's kind of where our issue is. If it's a drawing, it's not a real person. It's a artist's rendering of a person. It's not something that I have ever been involved in charging for a drawing of a person.
So, and I'm not trying to cut you off.
No.
So you're saying that the interpretation as you understand it is that it has to be a real person. So you add to the law this indistinguishable from, so, but what about, you know what a hyper-realistic drawing is?
Not
A hyper-realistic drawing is what some artists can do that effectively looks like it was a picture, right? An actual picture. So you could have a hyper-realistic drawing of the exact same image that you produce with AI, but that under this change would be permitted and the AI would not.
Yeah, I believe I would. So generally, we sit down with our prosecutors who will review what we have. And if we have that hyper realistic drawing that you can't determine from a picture, I mean, that would be a depiction that they would have to, they're the ones that are going to have to defend that in court for charging purposes. So it's going to be their call on whether they believe that that should be charged. And then it's up to the trier of fact to determine if that's a real kid.
And if it's not a real kid, even though it's a hyper realistic picture and effectively is the same as the other image, there's likely, I can't say, right, we're not in court, but there's likely nothing that could be done, you're saying.
Yeah, I mean, yes, that's my belief. I mean, there are plenty of realistic looking images that I look at and say that that's not real. That's not a real person. It looks really real. And I wouldn't even bring that to our prosecutor. But in some instances, like you're talking about, if I can't make that determination and it's a 4-year-old, then I will seek the input of the person who's actually going to be prosecuting that.
But ultimately, the system as it would be, should we pass this bill, would eventually say that doesn't cross whatever threshold offends us to the point where there should be some form of prosecution.
Right.
That's a thing. And as you're testifying for this, this language, and I know you didn't put your pen on the paper, but I guess I'm asking you if you're comfortable with this language, because in 16, which is lines 87 through 95, where it talks about indistinguishable and what it means, I still don't know what that means, because indistinguishable means virtually indistinguishable.
So you're right. I didn't write this, and I don't like the word virtually, just because we're talking, people will confuse that with computer, like virtual reality. That's not what that means. It means, would an ordinary person say that that is a real kid? Even though we just made that depiction, would the ordinary person say that's a real kid? And this is what's happening to that real kid. That would be virtually indistinguishable. If we had a drawing and showed that to the ordinary person, they're going to say that's not a real kid, and that is distinguishable, so not criminal.
And I guess maybe I'm asking because I'm unclear. I think if I remember, and I can look back into it, but correct me if you think I'm wrong. I think as I read it, it suggested that the ordinary person was the community, and for the intents of this bill, the community is the state, right? So I don't know what that means. I don't know how we actually judge who those ordinary folks are. And if the state is like, and I know this maybe sounds crazy, but it's important, right? The state is what we think is a coalition of folks and average, or if the state is those who are prosecuting it and their ordinary opinion. I just don't know. It feels like there's too much vagueness in this bill as it currently sits.
I think the ordinary person at the end of it is the juror, and it's on the prosecutor to meet their threshold of, this is indistinguishable from a real person. This, for all intents and purposes, this is a real kid that we don't know their name. And it's on the prosecutor to meet their threshold. And then it would be on a jury to say, that's a real kid.
I appreciate that. I have a lot of concern about clarity and vagueness in this bill. Senator Ciccarella, up.
Thank you. Thank you for coming, Detective, and advocating for a piece of legislation that is needed. It's a tool that's going to help you to arrest and hold accountable individuals that are in possession and dealing in child pornography. All too often we see that sometimes there's loopholes and people will exploit them. And it's my understanding that people could use the defense that this was generated through AI, therefore not a real person, therefore illegal, or not illegal. And this would attend to correct that. And as the good senator said, it is a little confusing. And maybe we need to go a little further. I don't want to put words in his mouth, but any type of child pornography is just unacceptable in my opinion. And we should definitely do something to fix this. I do have a couple of quick questions for you. We're talking about drawings, we're talking about AI, and I'm just trying to get clarity. So if it's indistinguishable whether or not it's a real person, that's one way, technically, just generalizing, somebody could get off of this charge. Is that a fair assessment?
If it's indistinguishable, they would be charged. If it's distinguishable, if you look at that image and say, that's not a real kid, it looks real, but it's not a real kid, that would be distinguishable and not charged.
Got it. Okay. And then if the age is the other question,
Yes.
correct? So same application,
Yes.
they wouldn't be charged.
So the age pretty much starts with the investigator reviewing all these images, saying these are kids under 15. But like I said earlier, generally we're not on the line of 15, 16-year-olds. We're looking at 8-year-olds, 5-year-olds. So the age thing is less of a burden to overcome.
Got it. And as we talk about the different types of images that you may come across, whether it is a drawing and people are talented and they can make something look real, or if they're utilizing AI, there's a lot of different things that we could see, right? Somebody could take someone's face and they're just, playing on a playground, they have their face, but then they use AI to make them do other actions that would qualify for child pornography. Would that be considered a real person because they're using the face, but the actions that they're doing is not real?
So yes, I believe, and I don't know how it's been tested through the courts, but I believe currently that image currently would be illegal because it is a person and it's computer generated to look like they have no clothes on. But the key comes down to, is it a person? And that would be a real person.
Got it.
Regardless.
So here's a concern, and this is something maybe that we have to try to find a solution to. With this technology, you could take, my picture and Senator Berthel's picture, blur them together, and it would be a
Very handsome.
yeah. Oh, I heard someone talking over there. It wouldn't be anyone, right? It's not.
It wouldn't be a
Senator-
person.
Okay, so it wouldn't be a person.
But you would still have that image, that depiction out there of 2 10-year-old boys. That's not a person.
Got it. And that's
It's
exactly
not
what
illegal currently.
and that's the problem. That's exactly where I'm going. That people will exploit this loophole. There is, you can't tell the difference, right? When they make these generated, images or even short clips,
Yep.
it's mind blowing that you're like, this person's not real. It's crazy. These avatars, it's really crazy how real they look. And that's the concern that I have, that this is a loophole. So technically you could create a whole market of AI generated porn, and it's still going around. And that's still something that bothers me. And I think it bothers everyone up here and anyone that's listening to this. And I don't think that this before us fixes that. I think we actually have to go a little further. I'm not saying let's not move this over to finish line to give you some additional tools and prosecutors tools, but I do believe that we should go a step further and make sure we're capturing all of the things that you're seeing out in the real world. Too many people don't realize the terrible things that you guys see on a daily basis, and they think it's made up or it's in the movies. And my last question, if the control allow, how often are you seeing this? I know you're just one department, but I'm sure you collaborate with the state. I mean, how often are you seeing child pornography being distributed throughout the state?
Every day.
Every day.
Yes.
Okay. All right. All right. Well, I truly appreciate you taking the time to testify and look forward to see if we can make this a little stronger and give you guys the tools you need. Thank you so much. Thank you, Chair.
Thank you, Senator. Representative Howard.
Thank you. Good morning or good afternoon, Detective. Thanks for being here. And I apologize, I had to jump into transportation. I heard a lot of the back and forth about AI and the computer generated depictions. Did you touch on, going back to line 72 and 73 of the bill, the subject of such visual depiction appears indistinguishable from a person under 16 years of age? Is that because when you find child abuse sex material, say on somebody's computer, let's just take AI out of it. And let's assume you found a box of Polaroids, right? For those who are younger listening, that's how we used to take pictures. You couldn't really manipulate them. And there was a bunch of kids on there, and they appear to be 13, 14 years old, but you can't identify them. Does that create a problem for prosecution if they're not actually identified under current language?
No, you don't have to identify every victim of it. The burden is just on the prosecution to prove that that person was under 16 at the time the image was, or the Polaroid was taken.
But how would they, but wouldn't that create an issue with absent the proposed language? Doesn't that create an issue? Because how can you prove that somebody is under 16? I'll use my wife, for example. She didn't look anywhere near her age. So how do you you run into problems like that where you can't, the prosecutor, if they're 14, 15, they, without identifying them, they can't really show the trier of fact that they're under 16?
That's pretty much the way we operate. If
Okay.
they're on the line of, I mean, there are kids that I'll say that kid's 13, but that kid could be 15. And if they could be 15, they could be 16. And we can't prove that. So the burden is on us. It's pretty much just reasonableness.
Okay. Well, thank you. Thank you for the questions. I will just say for the record that Detective Conway was my 293rd classmate, the 293rd Training Division in the Post Academy in 2002. So several gray hairs and a few pounds ago, we looked a lot different. But thank you for being here.
Representative Stavstrom.
Thank you, Mr. Chair. Thank you, Detective, and thank you, Senator, for being here. So we've spent quite a bit of time sort of talking through this language, so I'm not gonna go through it again. And frankly, maybe these questions aren't fair for you. I'm just not sure how many people are going to get to testify on this bill today, sort of looking at our sign-up list. But I guess I'm focused on the testimony from the Division of Criminal Justice on this. I don't know if you've had a chance to look at it, but
No.
they've raised, I think, some pretty significant constitutional concerns with this language. So, I mean, we can sit here and we can say, what should be criminal conduct, what shouldn't be criminal conduct, whatever. But obviously, we need to be guided by what we can and cannot make criminal conduct, right? And I think a lot of the questions you've been asked by, I think, Representative Fishbein and Senator Winfield and others sort of get to a potential vagueness challenge to this language. But there's also a free speech, I think, concern that's flagged by the Division of Criminal Justice. And I guess sort of I guess my question to you, without, recognizing probably you haven't done a constitutional analysis on this, but sort of whether you want to respond to any of those concerns that the division has raised. I mean, you've mentioned a couple times, we'll arrest them and they'll figure out what they can prosecute. But it sounds like here what they're essentially telling us is they're not going to be able to prosecute under this because of the constitutional concerns with this language.
Well, I think, I mean, there's more to it than we'll arrest them and let them figure it out later. There's probable cause in our training and experience. And will I put my reputation on the line to say that that is a 10-year-old? I don't know the concerns from the state. But as I was saying, I know the federal definition was argued and initially overturned for free speech because it was overly broad. Rightfully so. But since 2003, I believe, the current statute it has not been challenged that I'm aware of successfully, and they use the same terminology, nearly indistinguishable.
Okay. Yeah, I guess one of the things I'm always worried about is sometimes we may pass what is well-intentioned law, or if somebody gets arrested, somebody gets prosecuted for, and then there is a challenge down the road, and a victim actually ends up in a worse position than they would have been otherwise because they've, now had to sit through a trial. They've now had to go through the whole process, and the conviction's not going to stand. So I think that is one of the concerns I have on this. So maybe you do want to follow up with the Division of Criminal Justice Senator kind of after this. Because like I said, they did sort of enumerate kind of several concerns with the language kind of as drafted. So
Thank you, Representative. Representative Fishbone.
Thank you, Mr. Chairman, for the second time. You know, from my perspective, I understand the First Amendment concerns. However, you know, it's for us to, whether we modify the Constitution or we pass a statute, to perhaps recognize that I don't think it's appropriate in this state for someone to be using a video game that depicts two 5-year-olds engaged in sexual conduct. And certainly the traffic in those mediums, I don't think is appropriate. Now, call me a Puritan or traditionalist or something like that, but I just don't think that we should be allowing for that to happen under the guise of free speech. That being said, Sir Detective, you mentioned that you're involved in some groups or task force or something with regard to this area.
Yeah.
Is that a task force that was created by this body?
So, no, there is a Internet Crimes Against Children's Task Force, which is nationwide. And every state has their own sub task force. So in Connecticut, it's run through the state police.
Okay, I think, you know, there's been a lot of discussion today. I don't think this language is clear. I don't think it goes far enough to capture everything that, at least in my mind, should be addressed in this area, this burgeoning area, right? So, you know, perhaps creating a task force of some sort would be appropriate, because I see a lot of work, but a lot of good work. And let's just get this done right the first time. So, but thank you, Mr. Chairman.
Mr.
Thank
Chairman,
you, Representative.
may I make a comment?
Yes.
Thank you. So it appears as though I'm looking quickly at some of the testimony. It looks like there's testimony submitted by the Chief State's Attorney on 1439, which is what Detective Conway and I are here before you on. Also SB 1440, which deals kind of with the same topic, but not with the proposed change to the language with respect to indistinguishable. So I'm happy to work with the committee and get with the state's chief attorney. And I hope that we're not at a point where we've stalled with this. I think there's time to perhaps work the language out and give the detective and his colleagues across the state another tool to prosecute these terrible crimes. So thank you, Mr. Chairman.
Thank you. And as you know, in this building, whether it dies in committee or not, nothing is dead till the gavel comes down.
I do understand that, Mr. Chairman. Thank you.
Thank you. Great. So next, thank you very much for testifying.
Thank you.
Next, we will hear from Sue Pape. Sue Pape. If not, we will hear from Estela Lopez Espelin.
Dear members of the Joint Judiciary Committee, my name is Estela Lopez Espelin, and I'm from Clinton. I'm testifying in opposition to Governor Bill 6872, an act revising and consolidating the hate crime statutes. I work directly with adult survivors of childhood trauma from marginalized communities, and I don't believe this bill protects marginalized groups. I ask you to oppose Bill 6872 because it subjects social justice activists to increased risk of surveillance and criminalization. The bill can be weaponized by powerful entities to promote authoritarianism in order to chill and suppress social justice activism. This bill allows for an increased police presence among marginalized communities. This bill targets grassroots activists who stand up for the marginalized. Organizers and activists sacrifice a lot of themselves to build an equitable world for all. They do it at a cost to themselves. Activists are at increased risk of vicarious trauma, health issues, and state violence. This bill contributes to increased mental distress in activists. And I think that is the point of the bill, to induce silence, lack of dissent, fear, paranoia, and stress. To me, preventing self-expression and preventing communication is a sign of a dysfunctional culture. In dysfunctional families, there can often be a code of silence to avoid discussing families' dysfunctional behavior, which enables child abuse and other unhealthy family dynamics. When there are patterns of hidden abuse being committed against marginalized groups, we have to speak out and break the silence. Political elites will use Bill 6872 to silence critics. By framing legitimate opposition as hate, this bill opens the door for politicians to weaponize hate crime laws. The long-term consequence of this bill is that activists will face increased legal retaliation, especially activists who speak out against the genocide against Palestinians and those who advocate for the LGBTQ community, immigrants, and the poor. Please vote no to Bill 6872 Hate Crime Consolidation Act because the language is intentionally vague and it can be used to punish social justice activists who do the difficult work of building an equitable world for all of us. Thank you very much for your time.
Thank you. Questions from the committee? Seeing none, appreciate you being with us. Ahmad Hamdan.
Hello. Thank you, Mr. Chair. My name is Ahmad Hamdan, and I live in Brookfield, Connecticut, and I would like to also stand in firm opposition to Governor Bill 6872. While I commend the intent of this bill to protect Connecticut citizens from hate crimes and consolidate the language into one bill, it is written with vague language that could be misconstrued and exacerbate the growing bigotry and hatred within the United States and provides room for peaceful protest to be considered a hate crime. A primary concern lies in the potential conflation of Zionism and Judaism through vague guidelines of what is considered to be a hate crime. Over the last year and a half, the American people have begged their elected officials to listen to their pleas for help as they watch their hard-earned tax dollars be used to fund a genocide on the Palestinian people. Over the last year and a half, genocide supporters have made an attempt to label those protesting this genocide as anti-Semitic in an effort to minimize their very real concerns. This conflation, if cemented into law, sets a very dangerous precedent. We know well how the conflation of extremist groups and religious groups may impact this nation. As a Muslim American growing up in a post 9/11 America, I experienced the hatred this creates firsthand. We must not do the same by conflating the genocidal actions of Zionists with Judaism. Since the beginning of the Palestinian genocide, we have seen both Islamophobia and anti-Semitism reach all-time highs. This bill does nothing to address this rise, but rather provides room for more of both. Another principal concern lies in the anti-masking rhetoric in this bill. Might I remind you that we are still in the midst of a pandemic. While COVID and neurovirus run rampant in the US, anti-masking legislature is designed to target the most vulnerable, such as low-income and immunocompromised individuals. Furthermore, it makes room for the identification and targeting of individuals exercising their constitutional right of protest. Such targeting has led to individuals like Mahmoud Khalil, who is a legal resident and green card holder, being taken hostage by ICE for protesting the aforementioned genocide. He was taken away from his 8-month pregnant wife 2 days ago, and his location is still unknown. This continued attack and targeting of primarily people of color who disagree with the United States government's poor decision-making is a continuation of the fascist agenda being peddled by the highest office in the United States. I urge you to vote no on GB 6872 as written and revisit with more meaningful definitions to address the aforementioned. I would encourage this to be done with the communities that are most subject to the hate crimes that this bill should aim to protect. Thank you for your time, and as always, Free Palestine.
Questions from the committee? Senator Kissel?
Thank you very much, Chairman Staffstrom. Less of a question. I mean, this is a governor's bill that's being addressed. So it really has nothing to do with President Trump or anything federal. And I think it's Governor Lamont's administration's attempt to consolidate all the current hate crimes bill and put them in one spot. Obviously, all the concerns being raised are felt passionately, and we're taking into consideration all of those concerns. But this has nothing to do with federal policy, and any references to things going on federally has nothing to do with this bill. This is Governor Lamont's bill, and he's not always, not very often on the same page as President Trump. So just wanted that on the record. Thank you, Mr. Chair.
Thank you, sir. Further questions or comments? Seeing none, thanks for being with us.
Thank you very much.
Next up will be J. Paul Vance.
Good afternoon, Mr. Chairman, honorable members of the committee. My name is Paul Vance. I'm an attorney in Torrington, Connecticut, and I am here both on my own and as a co-chair of the workers' comp section of the CTLA, as well as the vice president of the Connecticut Bar Association. I'm here testifying in support of House Bill 7141, which is a workers' compensation related bill. It does two things that I think are really important. The first, it closes the disparity between neck and back injuries and how they're treated under the Workers' Compensation Act. Specifically, it changes the number of weeks for a cervical spine from 117 to 208. For clarification, the permanent impairment that would be assigned to the back would be 374, and right now the neck would be 117. This closes the gap, and it makes sense as a compromise. It brings it more in line with the number of weeks for the master arm, which is 208 weeks. The second thing that this bill does is it addresses how unpaid permanent impairment benefits would be distributed when an injured worker dies without a spouse or without children. And it sort of cuts out the red tape and would make the payments go to the next of kin rather than be referred to the probate system. I believe these two changes make a lot of sense. I think it would help protect injured workers, and I do not think that it raises any costs. With that being said, I appreciate your time today, and I'm happy to answer any questions.
Thank you. Questions from the committee? Representative Fishman.
Thank you, Mr. Chairman. Good afternoon, Attorney Vance.
Good afternoon.
With regard to Section 2,
Yes.
you mentioned that under current law, the benefit would go to probate. I'm just trying to figure out what you're seeing there.
Yeah, I don't see a lot of it, candidly, Mr. Representative, but the way that it would work now, the benefits would go to the estate and become part of the probate system. The change would direct those payments to go to the next of kin, so they wouldn't have to go through the probate system.
Okay, I just, this language comes to be because I had in my district, a young man who was working for DOT. He was mowing the lawn along a highway, and he was hit by a drunk driver who was uninsured, and it was her third drunk driving incident. And the results of that case under the current law is there's actually no recovery. If you take out the underlying language, you'll see that there is no compensation for someone under workman's comp if they do not die with a child or a spouse. So that would not go through the probate system presently. The intent of this language is actually to give that benefit, to recognize the benefit that should be there, because, you know, we're told that in the employment sphere that the exclusive remedy is workman's comp, and ordinarily if somebody dies in the course of their employment absent workman's comp, they'd be able to sue the employer, let's say, for negligence. So the intent of that section is to close that gap. Do you read that? You see what I'm saying now?
I do.
Okay, thank you. Thank you, Mr. Chairman.
Further questions or comments? Seeing none. Thanks for taking the time.
Thank you very much.
Stephen Poloff.
Hello.
Hey, how you doing?
Hi, members of the committee. Yes, my name is Stephen Poloff. I'm an attorney here in Connecticut, based in New Haven. I'm not appearing on behalf of anyone but myself. I just thought, I'd give some perspective on SB 1442. Now, I've practiced before the CHRO. I'm familiar with its procedures. I submitted testimony just discussing some of my thoughts on how some of these procedural questions that the bill attempts to address might better be answered. But I did actually, I won't just read from my testimony. I wanted to offer some thoughts on this, purported expansion of individual liability. I think what is being missed here from the conversation is that this is not just an and I just to clarify, I do management side advice and counsel. I represent employers. I don't take plaintiffs' cases. And what this represents is a significant expansion of not just liability, but also jurisdiction of the CHRO. And I'll give an example. Connecticut follows, and this statute proposes agency language. Connecticut follows the scope of employment test. So to qualify as an agent, and when I say expansion of liability, I'm going with what the CHRO said that their intention is here. We're talking vicarious liability. If an employee acts in the furtherance of an employer, their vicarious liability can attach. But that's a necessary component. If that's missing, then there cannot be liability for the employer, and that'll usually be in situations where you have an intentional tort, say sexual harassment. If the conduct the tortious conduct had nothing to do with the employment, that's the kind of suit that wouldn't even go to the CHRO or right to Superior Court or maybe federal court, but typically Superior Court, and that's how it would be adjudicated. Under the CHRO, to take this very specific and very broad definition of what agency means in the employment context, that's the kind of complaint that could end up before the CHRO. And now, does the employee need to exhaust their administrative remedies? Must it be taken to the CHRO? There's a lot of questions here about, how that would sort of interact with existing law. I know that, a recent state Supreme Court decision was mentioned, but agency has long been understood under common law. Here and there, there's statutes discussing agency, but that test really has been a touchstone. And I'm a little concerned about some of this language, and I'm offering just general commentary about how this language would alter that. I appreciate the CHRO testifying, well, we've always done it this way. When you're changing the statute, you're expanding the power of an agency. I think we really need to consider the long-term impact of it, not just what a particular executive director or their staff might interpret it as such. So that is my commentary.
Questions from the committee?
Thank you.
I'll dig in just briefly on this. So I'm trying to understand, because like I said, I've read the bill, I've read the Supreme Court decision, which I would note is a 4-3 decision. So oftentimes on 4-3 decisions, this committee is asked to, particularly where there's a written dissent that sort of suggests that there needs to be legislative clarity on the issue, that those are often the type of issues that get to this committee, where there's a 4-3 decision and we're asked to provide clarity, right? And so I'm trying to figure out, we've got testimony from the CHRO saying the bill that they've offered before us is essentially a codification of the practice and provides that clarity with respect to their agency based on the decision. I look at this as, if you're talking about vicarious liability, I mean, of course, if a supervisor is discriminating against someone, that ends up leading to vicarious liability for the employing business, right? I mean, that's existing law, that if it doesn't need to be the owner of the business who discriminates, that if the supervisor is the one discriminating against someone, that ends up in financial liability for the business, correct?
Well, I'd say it's fact specific. Sure. I mean, just as a boilerplate, that's usually the kind of circumstance that would lead to liability, particularly if they are threatening some sort of adverse employment action. I mean, that's really the key. But and when we're talking discrimination, that can take a lot of different forms. I mentioned I've actually worked on a case that's would probably fall within the ambit of this language. Sexual harassment, is that discriminatory? And it can be. in certain circumstances. Sexual harassment is usually, in many cases, if it's so overt, it's so clearly not within the scope of employment, it would not lead to liability necessarily. These are always fact-specific determinations, but it would not necessarily lead to liability for the employer. And, you know, that's sometimes appropriate. But to answer your question, I hope that's helpful.
Right. So under existing law, the existing statute says it shall be discriminatory practice for an employer, right? Or his or her agent. And there's a fact-specific inquiry under current law as to what constitutes the employer's agent or what does not constitute the employer's agent, right? Here, we're removing that ambiguity. What you're doing is you're making clear that the employer's agent is one who can either undertake or recommend tangible employment decisions affecting the employer or direct the employee's daily work activities. I mean, there's a way in which you could argue that this language actually narrows the definition of agency. Do you see that?
I see the language. I wouldn't agree. I think I would agree with it that it makes it clear. I think what it does is it clearly expands it in a very broad way, and I do worry that this could actually, I tried to provide an example of a case I've seen go to litigation, but I think this could be interpreted in ways the legislature might not expect. And what I would encourage is maybe to, if we're going to include something, a specific definition of agency in the discrimination context, maybe borrow a little bit more from the agency tests, really, particularly scope of employment, make sure that this test, and maybe it wouldn't be applied this way, but I think it's an open question, make sure that this test really captures that activity that is taken within the scope of employment, and it not just a situation where there's tortious conduct by someone who happens to be a supervisor that, they know this employer doesn't approve of, and nonetheless, the employer perhaps doesn't even know about it. But since the supervisor now becomes essentially the employer is nonetheless liable for something that they never knew occurred, that they absolutely didn't approve of. Under existing law, that there wouldn't necessarily be liability for the employer, and I think that this would be an expansion of that vicarious liability, where the employer would have less room to make that argument. Hopefully, that's helpful for your question.
Yeah, I get it, but I mean, I guess we have I guess we have that all the time. I mean, take any major national company, IBM. I mean, how do they ever know that somebody in one office, one place in the country is discriminating against an employee or sexual harassment? But the claim is always brought against IBM corporate as the parent, right? And I think here what we're doing, and again, not to argue with you, but I'm trying to understand what the concern is. I know that there was somebody sent me earlier today a blog post or something but I'm trying to figure out sort of where in the language the actual concern is, because I think so what you're saying is, I think what I'm hearing you saying is it needs to be clear that the discrimination needs to be in the workplace, as opposed to if somebody's employer discriminates against them, at the Little League field on the weekend type of deal. Is that what you're saying?
Sure. I mean, yeah, that could be one example, but it could be physically in the workplace. And, and this may be a policy disagreement. I might just be arguing a point that you or the legislature, as a matter of policy, thinks, well, we don't like that. And, and that's legitimate. That would be, then the legislature could make that change. But the reason I'm encouraging caution is because I do think that there's going to be some unintended consequences. And sure, right, maybe at the Little League game, there's some kind of harassment, could be sex-based, could be discriminatory, but the employer has no idea about it, doesn't approve of it, has nothing to do with it. And nonetheless, this person now, well, gee, they could make a recommendation about their employment. They've given them some day-to-day instruction. They are the employer. Now the employer is liable. And I think you could probably come up with a lot of circumstances where, I think based on the example you gave, you might be even uncomfortable with the idea of liability attaching I think that's the risk of expanding vicarious liability in such a manner where I think we could use a few more elements here. And that would just be my point about the law. I think it would certainly, I think, could be construed as an expansion of existing law for vicarious liability. I don't agree with the CHRO's testimony that, oh, well, this is just how we've always applied it. I could see this applying to other circumstances that might be unexpected.
Okay, fair enough. Further questions or concerns? Seeing none, thanks for taking the time.
Thanks.
Dominic Warsaw will be next.
Hi, I want to say thank you so much for giving me the opportunities to submit testimony. It's a privilege and I don't take it for granted. I am speaking in opposition to Bill 6872 on the consolidation of hate crimes. I say this as someone who belongs to a vulnerable community. I rely on hate crime laws for a sense of safety in my day-to-day life. I'm a visibly queer person with a 2-year-old, and the homophobia I've experienced as the far right pushes the idea that queer people are pedophiles is very different than the type of homophobia I experienced before. However, my opposition stems from the difference in how laws are intended, even by liberal governors like Vermont, and how they are interpreted or misused. I am also a practicing Jew who has stood in solidarity with the Palestinian people for many, many years. I am extremely familiar how frequently critique of Israel is conflated with anti-Semitism. So I'm very worried about that type of blurriness. I specifically want to remember with the representatives and senators before me a few years ago when a Palestinian solidarity protest on the New Haven Green made national news after one of the protesters draped a Palestinian flag over a menorah on the New Haven Green. And it was quickly taken down by the organizers of the event, but it was picked up by right-wing TikTokers and went all over national news. I think that in this environment, like many laws are going to be used to suppress free speech and to crush movements for social justice, regardless of how they were intended. I worry that that moment in that protest a few years ago could have become a felony under this expanded legislation. So I really applaud the intent. I rely on these protections myself. And I think a need for more specificity and honing in on like really those communities who like are truly vulnerable and need these protections, not those who are like just moving forward a political ideology. Thank you so much for the opportunity to share.
Questions or comments from the committee? Seeing none, thanks for being with us. Tate Lipchek.
Hello, members of the Judiciary Committee. My name is Tate Lipchek. I'm a resident of Hamden. I'm a medical student and community activist from a working class background who will, God willing, become a primary care physician to serve our country's public health needs. Today, I'm testifying in opposition to the Governor's Bill 6872. I also submitted written testimony. Throughout medical schools across Connecticut, medical students and faculty members have been faced with increased surveillance, repression, and punishment when advocating for the health and well-being of marginalized communities. Healthcare activists like myself are already facing hostile, for-profit healthcare institutions that prioritize upholding the bureaucratic status quo of administrative, legal, and executive barriers that deny healthcare to the most marginalized community members. What we do not need is having our democratically elected state government also taking measures to silence our voices. We need our state government to further protect our free speech and advocacy work, not undermine them, as this bill would accomplish, and certainly not to criminalize the use of masks. In the state of Connecticut, we have 17 billionaires, and the state is tied with Wyoming for the highest level of income inequality in the country as of 2021. This bill, while framed as a way to protect marginalized communities, would do the exact opposite. The changes enacted in this bill will open a new method for the billionaire oligarchs to exploit our legal system by allowing for the weaponization of hate crime laws to suppress legitimate political dissent and opposition in our community. This is especially dangerous right now as healthcare workers and medical students who support Palestine and Palestinian rights are losing their positions, being silenced and retaliated against by their superiors, also being doxxed and harassed online, being physically assaulted. And this is within the context of seeing our medical colleagues in Palestine whose medical schools and hospitals have been obliterated with weapons that have been paid for by our taxpayer money. Once again, this is another bill that helps organizations like AIPAC and the ADL, which I think stands for the Apartheid Defense League, to conflate anti-Semitism with the opposition to the Israeli government's policies. Anti-Semitism is a real problem in this country, and so is anti-Palestinian racism. We need to ensure that bills like this make it absolutely clear it will actually serve to protect Palestinian, Muslim, Black, Latino, Asian, Indigenous, and Jewish people like myself, and not just supporters of current governmental policies of Israel and America. And yes, Pluto here wants to speak too. And finally, once again, I urge you to vote no on Governor Bill 6872. Thank you for your time.
Thank you. Questions from the committee? Seeing none, appreciate being here. Brian Mezek. Brian, please tell me I can talk about hate crimes.
I don't have a cat either. All right. Representative Staffstrom, Senator Kissel, Representative Fishbein, Representative Fazzino, and members of the committee. My name is Brian Mezek. I'm a Connecticut State Marshal. I'm president of the State Marshals Association of Connecticut, a workers' professional organization that represents the marshals across the state. I'm here to support HB 7139, an act concerning the duties of state marshals. Let me just quickly highlight a couple things this bill does, and then I'll get to the good part. First, it updates several sections of law concerning operational matters for the state marshals, things like our insurance, collection of money, access to information that helps process get served. Second, the bill improves the way that various entities are served, for example, service of process on an LLC or service to a municipality. Okay, now the good part. This bill will modernize the state marshal system by broadly authorizing attorneys and public agencies to electronically transmit documents to state marshals. Now, many have wondered why that can't be done currently. I can tell you myself, I get several requests per week to do this. First, current law doesn't authorize this. Marshals are required to serve a true and attested copy of any process, and we've been given guidance that we can't accurately or lawfully do that unless we have the original summons. Second, there's also a practical concern where obviously professionals that are on the road, our function is to serve process. So opening up email to the marshals still means somebody has to print out the papers to make service on the defendants. So if the writ comes by email, that function will just be shifted to the marshal in some instances. So all that said, we're acutely aware that there are situations where attorneys need papers served with a quick turnaround. I think the example that Representative Staffstrom gave is a good one. Practitioner in Bridgeport needs a paper served on the other side of the state. Either mail delays or FedEx doesn't need to be involved. They would be able to email the marshal. There's also other scenarios like a subpoena, order for hearing of notice, summary process eviction that has quicker turnaround where this could be utilized effectively. So the bill would permit emailing a PDF to the marshal who would then print and prepare the documents for service. The bill has defined parameters, a set fee to compensate the marshals for this additional administrative task. So we support this legislation. We think it has good parameters and boundaries. I was here last week for one public hearing, and I think Representative Blumenthal called this the magic of service of process. So hopefully this bill will make the magic happen a little bit quicker. So thank you very much. And I'm obviously happy to answer any questions you might have.
Rep. Fishbein.
Thank you, Mr. Chairman. Good afternoon, Brian. Nice to see you. This is basically a lot of what we passed last year, right?
As to the other content, aside from the electronic service provision, yes.
And we heard last year that those other portions may help in getting more marshals to be marshals. Is that still the case?
Well, there were some sections last year about education and whatnot that is not contained in this bill. But the bill does generally streamline service process. I'm not sure exactly what you're referring to. We do have a need for more marshals. The commission's currently in a recruitment process, and there's an effort in earnest to appoint more in certain areas.
I believe we talked about requirements that marshals, that's their main job.
It is our duty to serve process and our obligation to serve
Understood.
process.
But the aspect of part-time marshals, under this language, is that concept basically to go away?
Last year didn't have that specific provision. I think those were a few things that we discussed maybe offline about how to get more people into this career full time. That's probably the purview of another committee and a health insurance component. Obviously, we're not salaried. We don't have any benefits. So a newly appointed marshal has to get going to be able to support themselves full time.
So when I look at the list of marshals, in Fairfield County, we have 30. Just eyeballing
Right.
the page.
Approximately, yes.
Hartford County, 40. Litchfield County, 9.
That sounds correct.
Middlesex County, which is geographically one of the largest counties in the state. Based upon the list, there's only 6 marshals.
Well, Middlesex County is actually geographically one of the smaller counties, really with only one city and one courthouse, Middletown.
Is that okay? So because we get to
Our largest areas are Hartford, New Haven, and Fairfield County. That's where most of the population in the state lives. Litchfield, Tolland, Wyndham, Middlesex, and even New London to a certain extent. There's less process being served there just because of the population.
Okay, maybe it's because I do a lot of stuff in Middletown Court. I mean,
Sure.
I've brought this up to you before. Yeah, I'm hoping that something can happen with regard to, because, only having 6 in that county is certainly,
I sit on the State Marshal Commission as one of the ex officio members from the State Marshals Advisory Board. And I know that the current recruitment process is specifically targeting Fairfield and Middlesex counties for new appointments. And the marshals themselves, we have advocated for more to be appointed in those areas because we know there is a need.
okay. Well, Fairfield, I mean, I don't know about the volume in Fairfield compared to Middlesex, but, currently based upon the list, Fairfield has about 5 times the amount of marshals that Middlesex County
I
does.
think if you looked at the population of the counties, I think Fairfield County has over 1 million people. It's the most populous county in the state of Connecticut with 3 courthouses. So that's why there's more in Fairfield, but there's a need for more in Fairfield now.
Okay, no, I appreciate that. It's, especially on restraining orders, or emergency orders for
Right.
custody, anyway, but I'm in support of what's before us, and thank you for coming here today.
Thank you, Representative Fishbein. Brian, I think part of the Fairfield County issue, as you alluded to, is there's 3 judicial districts that make up Fairfield County. And so even though a marshal is a quote unquote Fairfield County marshal, we all know that the trip from Bridgeport to Stamford and vice versa can take an hour and a half to 2 hours at times. And so I think part of the problem is even though you have 40 Fairfield County marshals, there's marshals in Bridgeport who will not serve papers down in Stamford and vice versa, because frankly, it's just not worth their time to do that, to drive from Bridgeport down to Stamford to serve papers and turn around and come back, right?
Right. And I mean, I can represent to you, if it were up to me, and everything's not up to me, we would be appointing maybe almost 20 more Fairfield County marshals, because I know there's a need. We need to get up to a certain number in that area. It has dipped low in Fairfield County, so I'm going to be encouraging the commission to appoint more in Fairfield County.
Yeah. Well, Brian, thank you. And I know, you know, I really, I need to publicly thank you for the amount of work you've done sort of over the off session. I mean, getting to the point of being able to, we're in 2025. A lawyer should be able to sit at their desk in Bridgeport and say, hey, I've got this summons and complaint that has to get served in New London, and be able to email it to the marshal in New London for that person to print out and serve, and not have to deal with, all right, I got to mail it out there and I got to get it. And then I mail the process back, and you're adding 3 days, et cetera. So, you know, it's been a priority of mine to get us to the point of being able to do that. And I need to thank you for doing that. I did know, there was some testimony from the judicial branch sort of on, I think, it's really just some wordsmithing, some technical stuff. So, you know, not to put more work on your plate, but if you could get together with them in the next week or so here, and just let us know if there's any tweaks that we need to make to this language based
Yeah,
on.
I'm confident that we can work that all out and have a good product by the time you guys have to get bills out of committee.
Great. Appreciate it.
Okay,
See
thank
no
you.
further questions. Thanks for sticking with us.
Thanks.
Sachin Pandya.
Afternoon. My name is Sachin Pandya. I'm a law professor at the University of Connecticut, and I support HB 6872. That's the bill that revises and consolidates the state's hate crime law. I was involved in advising the Hate Crimes Advisory Council in the drafting of the bill, along with my colleague Richard Wilson, who's also in the queue. What I'd like to do in my time is refer you to the written testimony, but also talk a little bit about the importance of consolidation. And then, if you're willing, address each and every one of the questions you've raised about the drafting. I think there's a lot of misconceptions in the past couple of hours about the bill, and I'd like to clear those up now. The importance of consolidation can't be overstated. The idea is simple. If you put all the hate crimes in one place in the penal code, they'll be easier to find, and a police officer or attorney could simply scan that chapter's table of contents to find the hate crime that fits the cases that they're handling. We shouldn't force them to waste their valuable time hunting for and then deciphering Connecticut's hate crime statutes like a bunch of law professors. For how important this is, I would refer you to the written testimony of Police Chief Faraci. Among other things, the chief describes a recent incident in Norwich where a person was arrested for spray painting swastikas, but wasn't charged for a hate crime. And in the reporting, Chief Faraci notes, when the Norwich police chief was interviewed, he said that the investigators searched the criminal statutes, which were a bit scattered. And even after consulting with the state's attorney's office, they couldn't find a statute that applies. And so I think it's really important to give them the tools all in one place to do this. Second, let me clear up this misconception now. The primary goal of this bill is to consolidate existing hate crime statutes in one place. Every hate crime identified in sections 2 through 22 of the bill, it has its origin in a hate crime in existing Connecticut general statutes, in the existing section of that law. I think the difficulty maybe here is that when the LCO drafted HB 6872, they amended some portions and then they labeled other portions as new. And strictly speaking, they were new because of the difference in label, calling them a hate crimes, as well as some changes to the underlying underlying language regarding in whole or substantial part, but in most respects, those derive from existing hate crime law. And so I can do this in one of two ways. One, I can go through the list of questions that you all have posed to others, or if you wish.
Well, there's a bell, so what I'm going to suggest is we open it up to questions from the committee. I'll take the bait first, I guess. So you said sections 1 through 22 have origins in existing law.
Yep.
What about sections 23, 24, and 25?
Right. So 23 refers to the persistent hate crime offender statute, which is also an existing law. It's not strictly speaking a hate crime. So in that respect, it is modifying that provision to cover all hate crimes, not just for some reason they've excluded some of them. What is new is 24 and 25, which are the hate crime penalty enhancements. And I know you had some questions and we can talk about that as well.
Yeah, I mean, I guess my question, I mean, it's a policy one, right? I mean, I oppose mandatory minimum sentences.
Yeah, so let's talk about that. The hate crime enhancement statute has two important features that I want to highlight. The first is that it in itself is not a mandatory minimum. For physical injury or property damage, if the underlying offense is of a particular class, let's say it's an A misdemeanor or a C felony, the evidence of a motivation based on race or religion or another social protected category bumps it up to the next class, right? So if the underlying crime is a C felony, it'll go to a B felony. If it's an A misdemeanor, it goes to an E felony. It's only a mandatory minimum in the sense that you're talking about. When we have the underlying crime as a class A felony, there is no class above A. And so the question is, how do we proportionally punish people who commit an underlying class A felony to account for the fact that they did it with motivation based on religion or race? And in that respect, I think there is a perfectly respectable policy question about how best to craft that.
So let's look at lines 387 through 397. So this is section 24 of the bill.
Yeah.
Except as otherwise provided in the section, for any defendant guilty of a list of crimes set forth herein, motivated in whole or in substantial part, protected class. And then we get down to, if the crime is a class A felony, the court shall not suspend or reduce 25 years of sentence or imprisonment. Okay.
Yeah.
If the crime is a class A misdemeanor, the court shall impose the sentence of imprisonment for a class E felony as authorized by. Okay, so that's what you're talking about the enhancement from the misdemeanor to the felony.
Yes.
charge.
So the first line says if it's a felony of a particular class, you bump it up one. You can't use that for a class A, so that's what the next sentence does. And then because we're talking about a jump from a misdemeanor to a felony, the last sentence refers specifically to a class A misdemeanor bumping up to an E felony. So the quote unquote mandatory minimum issue only applies with respect to what you do for a person who's committed the underlying crime of a class A felony.
Right, but then if we get to 387 to 397, for any defendant guilty of any crime set forth in, again, a list of sections, conspiracy to commit any crime or attempt to commit any crime. If the finder of fact determines beyond a reasonable doubt that the defendant intentionally selected any person against whom the crime was committed as part of being a member of a list of protected classes, the court shall add 1 additional year to any portion of the term of imprisonment that the court may not suspend or reduce.
And let me explain what that provision is doing. So sections 53A, 59A, 53A, 60B, and 53A, 60C are all existing provisions which provide additional penalties where the assault is committed by someone with the knowledge that the person being assaulted is elderly, blind, physically disabled, pregnant, or intellectually disabled. So if you had a plain vanilla penalty enhancement for that, it would be disproportionate because the underlying offense already accounts for the status of the individual's victim, whether they're elderly, whether they're blind, and so forth. The only difference is that those underlying provisions require proof that the defendant knew they were elderly, physically disabled, blind, pregnant, but they don't require that they were motivated by that status. And so this is actually an effort to calibrate those particular provisions with a penalty enhancement by simply saying there are already existing mandatory minimums for those provisions. All this does is to recognize the jump between knowing somebody is blind and being motivated by the fact that they're being blind by adding one additional year on top of what the mandatory minimum is. It doesn't create the mandatory minimum. It's trying to rely on the existing structure of the underlying crime.
Well, except that added year cannot be reduced or suspended.
That's
So-
correct.
So you're taking a mandatory minimum and you're compounding a mandatory.
By year, that's right. And so again, there's a policy choice about how you would proceed, but the idea here is proportional punishment of the motivation to assault based on being pregnant or blind has to account for an additional increase in punishment. Now, whether you do that by increasing the mandatory minimum by a year or something else, I take your point that that's an appropriate point for policy discussion, but that's all that provision is trying to do.
Well, especially because here, the way this is drafted, if I understand it, the act of committing the crime and the act of attempting to commit the crime are charged the same way.
Well, that's no different than the original provision in the previous paragraph. Conspiracy to attempt to simply follows along the way in which Connecticut criminal law otherwise deals with charges based on conspiracy or attempt.
Right, but I guess my point is you're adding this additional year that cannot be suspended, even if the person merely attempts the crime but is not successful in accomplishing the actual assault.
If someone under current law attempted to assault somebody because they were elderly, the underlying crime, the assault because they're elderly, governs the punishment that they have. So that doesn't depart from the way in which Connecticut criminal law deals with conspiracy or attempt. It just tries to deal with the law as it is.
Okay, so let me flip back to section 14. I don't know if you're here this morning when I gave, this is the
mask stuff
situation.
Yeah.
And I will acknowledge that masks or hoods, there was an existing provision in our statutes on that. I think, you know, the issue here where it's being highlighted is because we're now, you know, we're essentially reducing the, or I should say you're increasing the likelihood it can be charged because the crime no longer has to be motivated in whole, but substantial part. So you're reducing sort of the, reducing the threshold and sort of increasing the likelihood that this crime could be charged.
Let me
right?
give you the context behind this. I think there's been a lot of misconception about this mask provision. So let me just lay it out first, and then I'll answer your question directly. This was a statute that, along with the property desecration statute in 46A, 58B, was enacted after in 1979 and 1980 in Connecticut. There were a wave of cross burnings, which alarmed people, cross burnings all throughout the state, and which coincided with the state tour of a then young 29-year-old representative of the KKK named David Duke. And in response, there was a lot of concern, and out of it came the desecration statute in 46A, 58B, as well as this mask provision. The mask provision, I think it's fair to say, was really interested in thinking about the Klan. Fast forward. And what you have here is a provision that we looked at the judicial branch statistics from 2000 to 2022, the number of times this provision has been charged, not convicted, charged, is 0. Okay, that's the context. What we're trying to do here is only 2 things that are what we're doing with all the other statutes. Number 1, we're calling it a hate crime, as all hate crimes should be called. And second, because there's inconsistency in the causation requirements across, we conform this to the in whole or substantial part language that appears in most of the other hate crime statutes. So you're right. Originally, as it exists in current law, in 46 in 53-37A, it refers to on account of religion, race, and so forth. Here we change it to motivated in whole or substantial part by, and then all the other. And that's because that causation requirement, motivated in whole or substantial part, is what's currently in the intimidation statutes and many of their more recent statutes. And so part of consolidation includes the goal to try and streamline it, again, to make it easier for police and for attorneys to understand. That being said, consolidation means that you can fix some things, but it also means that you have to, if your primary goal is consolidation, move a lot of stuff that's imperfect into one place so that you can see the imperfections. A lot of people that have testified just now believe that this mask provision is wholly new, even though it's been on the books for, I want to say, about half a century. And so that's the struggle here, consolidating it, putting it in one place, while at the same time.
But I think that highlights the concern.
Yes.
Right? I mean,
Yes.
the whole point, as you just said, you started your testimony with, we need to consolidate this stuff to put it all in one place so the police can open up a book, they can flip through it and say, oh, gee, here's this provision nobody's been charged with in Connecticut in 2.5 decades. Let's start charging people under it, is I think the fear and the concern.
Yeah, I think that's a legitimate concern, but I think there are pretty simple ways to address it. So Senator Winfield, for example, talked about the concern that there's an ambiguity as to the device designed to conceal the identity. One possible change that the committee might consider is simply to add the phrase designed and intended to conceal the identity. There, we don't have to deal with whether or not one particular type of hood or mask was designed by the product maker. All we need to concern ourselves about is the intent of the wearer. Now, I'm not suggesting that this is the only way to do it, but there are sensible ways to conform this to deal with what are some obvious concerns that people have. But I do want to stress that we don't want the tail to wag the dog here. We can make these changes, but the ultimate improvement is to get all this stuff in one place and to make it internally coherent.
I get that, and I get that from an academic perspective, certainly. I guess from a policy perspective, from our perspective, I think I'll just lay it out there. The question I'm wrestling with as I'm sitting here today is this bill ready for prime time this session or not? And the reason I ask that is because, I mean, it seems like the language we have before us is a good first step, but are there unintended consequences to it? And are there broader sort of policy discussions or issues that have been highlighted by this exercise of pulling it all together that really can and should be flushed out? Because oftentimes what happens in the legislature is we do a wholesale rewrite, we pass this bill, and then nobody's going to look at it for the next decade.
Okay, so Representative Strastrom, let me try and convince you that this bill is, as you suggest, ready for prime time, that it is worth passing, and that it's not a wholesale rewrite, but it is a rather modest effort to put everything into one place. And I'm going to do that by identifying every single one of the concerns that you and your colleague have raised, and to show you why those aren't serious concerns worth delaying what is an important piece of legislation to deal with hate crimes. You've identified the mask point, and I totally understand where you are with that. I hope I've clarified a little bit the mandatory minimums. I would like to address Representative Fishbein's concern about the status as a victim of domestic violence, if I could.
Yep.
So Representative Fishbein asked several people whether or not this is an expansion. Let me say it plainly. This is not an expansion of existing law. To the reference to status as a victim of domestic violence already appears in current law in section 46A, 58A, where it has a list of particular categories and adds status as a victim of domestic violence, and in section 46A, 58C. And if you look at the way in which the definition sections of the bill is drafted, I refer you to the definition of protected social category. You see that phrase, except that for section 11 or 13 of this act, protected social category also includes status as a veteran and victim of domestic violence. All that does is to say, for those provisions of this bill that correspond to 46A, 58A, and 46A, 58C, we also cover status as a victim of domestic violence. In other words, it imports the structure of existing law. It does not expand the use of the phrase status of victim of domestic violence in the way that some people may confusingly have believed. And if you want to check me on that, go look at section 11 and section 13 of the bill, and you will see what corresponds to 46A, 58A, and 46A, 58C. This is not an expansion. Now, I do want to be absolutely accurate about this. There is no definition of the phrase victim, status as a victim of domestic violence. That's
Right.
because there is no definition of status as a victim of domestic violence in
Right,
subchapter
I will,
814C.
yes, I will stipulate that that language appeared in a Senate bill from a couple of years ago, and I will agree that it's not new language. All right, I'm going to turn over to others with questions. Representative Fishbein.
Thank you, Mr. Chairman. I'm just trying to follow. So I pulled up 46A 58, and you're directing us to A, parent A, right?
Yeah, so that's right, section,
Okay.
yes, that's right, I'm sorry, go ahead.
So I don't see the term in here, status as a victim of domestic violence in, oh, okay.
Do
Okay.
you see it at the very
Status
end?
as a veteran or status as a victim of
Yeah.
domestic violence. Okay. Okay, so one of the prior testifiers did say that was an expansion.
That's incorrect.
But it's your testimony here today that this is a rejiggering, this is part of the consolidation.
That's correct. And the
Okay.
consolidation only limits that category, along with status as a veteran, to those provisions in the current bill that correspond to the existing provisions.
Okay, there was another. Do you know when that it became part of this? That
When, I'm
clause,
sorry?
Status as a victim of domestic violence.
Oh, when it was added to 46A, I don't know off the top of my head.
Do you know, since you did reference some data, if anyone has ever been prosecuted under that portion?
I don't know the answer to that.
Okay, I thought I did have another question, but I'm going to defer, so thank you.
Okay.
Representative Howard.
Thank you, Mr. Chairman. Thank you, sir, for being here. I had a few questions earlier that I'm not sure if you haven't quite touched on them yet, but you talked about proportional punishment based on motivation. And I agree with you. And if you heard me in my dialogue with the Chief State's Attorney's Office, I agree that these crimes and their motivation are unique, right? And it seems you would agree. So in the context of the mandatory minimums, and I appreciate what you're saying in your back and forth with the chairman, Do you understand the concern that I have that there will be plea bargaining to avoid these mandatory minimums and thus take the hate crime away?
I understand that concern, yes.
So is there a manner in your eyes where we as a legislature, as a voice of the people, can make it clear to the judiciary that we agree as a state that crimes motivated in hate are proportionally need proportional punishment? Is there a way we can do that without creating the scenario of these, plea agreements to avoid the higher charge? And if you don't,
Yeah, so it's a hard question to answer because
Of
I
course.
think you're asking, is there a way the legislature could cabin the discretion to engage in plea bargaining between prosecutors and defense attorneys in situations involving hate crimes? And that's a hard question for me to answer in the abstract.
Would it be, well, it's not really in the abstract because it happens here every day. You heard the chief state attorney's office say that, right? So
I don't dispute that plea bargaining happens every day. I think what's difficult is there a surgical way to write legislation that would do what I think what you're getting at, which is to constrain the discretion. I'm not sure that either the chief state's attorney or the public defenders would like that very much, number one. And I'd want to think a little bit more about how precisely to do that. Again, this bill's goal is quite modest. It can't solve all the imperfections in the hate crime law. All it wants to do is put it all in one place, create these hate crime penalty enhancements because our law doesn't cover most serious crimes, and to call them hate crimes. And then the Hate Crimes Advisory Council would be best situated to take up many of the other important policy questions, including the ones that you've identified.
So you also talked about the language of motivated in whole or in substantial part, which has been quite a top conversation here today.
Yeah.
Earlier today, one of my colleagues, I think it was Chairman, gave a scenario where a young person is outside of a convenience store and he's creating too much noise, and another person comes out and says, an older person comes out and says, "Hey, go away." And the kid yells back at him, "Listen, old man, I'm not going to take your grief," and then assaults him. That a hate crime in your interpretation of this language?
So I think the hard part about the in whole or substantial part, I'm not trying to dodge your question. I'm just trying to think through the scenario.
Well, just as you think through it, let's remember that police officers have high school educations at a minimum, and you're a law professor. So we're asking, okay? So we're asking these police officers to make this determination. So I'm asking you, in the scenario that he posed, is that a hate crime? What is the motivation of that? Let's just assume that the kid's 18, right? Because it takes juvenile aspect out of it. Was he motivated by the fact that the guy came out and yelled at him? Or was he motivated by the fact that the guy was old?
I think it would be a difficult proof burden because proof has to be ultimately beyond a reasonable doubt. And if there's ambiguity there, that cuts in the defendant's favor.
Okay, so, all right, I appreciate it. I would agree. I mean, my reading of the language is that that's not simply that he noted that the man was old. It doesn't.
I mean, would it be relevant evidence? Sure. Would it be enough to pass reasonable doubt? I'm skeptical.
Well, all right. So let's assume the person's overweight. They're not a protected class, right?
No.
So if instead of the shop owner who's old, he comes out and he's heavy, he's overweight, and the 18-year-old says, "I'm not going to take anything from some fatty or some negative term." Isn't that the same thing?
What do you mean? Isn't that?
In other words, if two shop owners walk out and in two separate scenarios, and a guy happens to be old and one of the shop owners happens to be fat, both happen at the exact same time, two different 18-year-old kids, one yells, "Hey, listen, I'm not taking anything from an old man," and then, leave me alone. The guy keeps yelling at him and he hits him. Or, "Listen, I'm not going to take anything from some overweight guy," and the guy keeps at it and he hits him. What's the difference in the scenario?
In both scenarios, there's pretty weak evidence to believe that the motivation for hitting them was because they were old and overweight respectively.
So we would agree that that wouldn't be a hate crime in the earlier.
Well, we wouldn't even get to that stage because one's overweightness status is not a protected.
In the original case, so that's my point.
Right. In the original case, the question on the table is whether or not the person was motivated in whole or substantial part by the person's actual or perceived status as above 60 years old.
All right. And then I had asked the state's attorney's office, jump into lines 122 to 129 of the bill.
Mhm.
In line 125, it says damaged as a consequence of such violation in an amount in excess of $1,000. That seems to me, that's not a fine in line 125. That's an element of the crime based on the value of the damage. You would agree?
Yes, this is this course, again, this is for consolidation purposes, the structure of 46A 58E, which sets different classifications for destruction of a house of religious worship, depending upon the amount of the dollar amount of the property destroyed. And so all this is doing is intended to import that.
What was that statute again? I'm sorry.
46A 58E. If you look at E2, and then you'll see in E2 the language which refers to the property damage as a consequence of.
And I just, it's gonna take me a minute to get it up here.
Sure.
But so I can't see it now, but you're saying it in both scenarios, in current language, both of them say an amount in excess of $1,000. Because if
Yeah,
you,
so subsection 2 says, any person who violates the provisions of this section by intentionally desecrating a house of religious worship, that's the old language, A shall be guilty of a Class D felony and shall be fined not less than $1,000.
hold on 1 second, sir.
Yeah.
I'm in lines 122 to 129.
No, I'm reading, my apologies. I'm
Okay.
reading 46A 58.
All right, so
E2.
yeah, go ahead then. I'm sorry. Go ahead, because I want to hear.
I'm sorry. The only point I was trying to make is that that is a carryover to the lines you're referring to.
All right, well, can we look at 122 to 129?
Yeah.
It says a violation of subdivision 1 of subsection A shall be a Class A misdemeanor, which we'll get to in a minute, for which the court shall impose a fine not less than $1,000 if property is in amount in excess of $1,000.
Yeah.
Or it's an E felony for them to impose a fine not less than $1,000 if the property is in amount in excess of $1,000. In both cases, it's an amount in excess of $1,000. So explain to me how, if we're making this easier for police, I'm a police officer and that is not easy. That makes, in my opinion, I'm not a law professor, that doesn't make any sense.
Yes, it doesn't make any sense because it is obviously a drafting error. If you look at 46A 58E2.
But you're saying this is an existing statute, an existing language.
It was, for reasons I don't fully understand, they seem to have, there seems to be some issue with the drafting. It was intended to be an import of E2.
So as it sits, it's not an import of E2.
As it sits, it seems to be, I'm not exactly sure. I'd have to look back.
Okay, and then can you tell me why we need section 5 if section 4 exists?
So section 5 is an effort to import as amended 46A 58B. 58B was one of these statutes enacted in the 80s during the cross-burning situation. In the original current statute today refers to any person who intentionally desecrates, and then it has a list of categories, and then it defines desecrate to mean mar, deface, or damage as a demonstration of irreverence or contempt. The difficulty here is that a couple of years after the statute was enacted, the Supreme Court decided a case called RAV versus St. Paul, which stands for the proposition that even a hate crime statute can be unconstitutional on its face in violation of the First Amendment if it entails, if its enforcement turns on the viewpoint expressed by the defendant. And so as a consequence of that decision, there is some constitutional doubt as to the validity of the 46A, 58B. And so the goal here was to remove that constitutional doubt by amending it to remove the desecration part, that's the viewpoint discrimination part.
Okay.
But to leave in the particular concern or regard for religious objects or houses of religious worship.
Okay, and then, well, the public defender's office sort of raised some of those same constitutional concerns. One thing that did stand out to me, and I don't have it in front of me, but it has to do with cross burning, et cetera. And maybe it doesn't matter, because it seems to suggest in the language that if it's your own property or you have written consent from the owner. So in other words, if I want to burn a cross on my own front yard, as I read the language, I'm still able to do that. I'm violating no law.
Without written consent of the owner. That's also in the.
Right,
language.
exactly. That, but
Yeah.
well, it doesn't say it here, but I assume that I wouldn't have to write consent to myself, right? I mean, written consent means, well, you're not the owner.
Yeah, so.
Right, so that's, in
that's
other
what-
words,
That, I don't see, I'm sorry, I interrupted, go ahead.
well, you can go ahead.
Yeah, so the cross burning statute is, as amended, responds to a Supreme Court case called Virginia versus Black, which concerned a similar cross burning statute there. And the court said in that case that the way the particular Virginia statute, as it was written, survived constitutional challenge. And so this was an effort by the legislature after Virginia versus Black to amend what was originally enacted some years ago to conform with that. So there's no constitutional issue with respect to the cross burning statute.
Okay, I think it covers all my questions. Thank you for being here. Thanks for your work on this. And thank you, Mr. Vice Chair, taking on. Yeah.
Thank you. Further questions from committee members? Seeing none, thank you for your testimony.
Thank you.
We have next Victoria Burke.
Good afternoon, Chairman. Good afternoon, committee members. Thank you so much for allowing me to speak. My name is Victoria Burke. I'm an attorney and I'm an adjunct law professor, and I'm in support of Bill 7134. I originally proposed this bill to Connecticut legislators, and it was proposed as HB 5595, and it's modeled after HB 5595 was modeled after the California bill, which I had proposed and drafted after my own personal experience. I myself had been drugged and sexually assaulted in December 2019, and I was left in a severe coma. And after I got out of the hospital, I went immediately to the police, hoping to go through the proper legal channels, which everyone's always encouraged to go through. And so I thought I was making all the right steps. And so unfortunately for me, though, the police ended up losing my blood evidence and also the video evidence, making a prosecution and arrest utterly impossible. So I remember telling a friend of mine what had happened to me and what I experienced. And she warned me, because she was a friend of mine from law school and a defamation attorney, to be careful when speaking out about what had happened to me and to not use his name and not use any identifiers, because it could open me up for litigation, that I could be sued. And I thought, sued for defamation? I thought I'd be protected from defamation when speaking the truth or speaking my opinion. It's either true that he drugged my drink, or it's either my opinion that he drugged my drink. And I was like shocked, because at this point, my only justice I could have was be able to simply tell my story. I couldn't get anything else at this point except to say something bad happened to me, and I'm really unhappy it happened to me. And to find out I was being restricted or potentially restricted made me very alarmed, because if my abuser could curate what I speak about and how I discuss what happened to me, then to me, it's a continuation of the initial attack. If he still can gag me, he can still control me. And I was very concerned about this. So I went about looking to see the national trend after the Me Too movement, and there had been quite an uptick of retaliatory defamation lawsuits that were used to silence victims. Now, when I say that, there's almost no way that these cases can be won, because there's very little evidence. Two people go into a room, two people exit a room, they both may have different opinions about what happened. If a period of time has passed and there's no evidence, it's very hard to say your version's untrue unless there's an element of malice where you could show the person has an axe to grind, the person wasn't even in the same state at the time, they've given conflicting reports. Stuff that would establish malice would likely prevail in a case. So I propose this bill.
Attorney Burke, we're at the 3-minute mark. Could you please summarize? Thank you.
Yes, I believe the fix that they have for 7134 would clarify that your anti-SLAPP bill would actually protect sexual assault victims, since the current bill that you have makes it open that public interest may not include sexual assault, and whether or not the statement can be made like a #MeToo statement on the internet, or if it can only be made to a judicial official, a legal official. And so this clarifies the protections that you already wanted for your citizens to have.
Thank you for your testimony, Attorney Burke. Questions from committee members, comments? Seeing none, thank you for your testimony.
Thank you.
Next up, we have Miriam Lisk-Durandish.
Hello, so sorry. Hello, respected members of the Joint Judiciary Committee. My name is Miriam Liska-Durandish, and I'm a music teacher, professional musician, and member of the New Haven community. I'm also a queer Iranian-American woman. Governor's Bill 6872 would affect my life. I'm testifying in opposition to Governor's Bill 6872 in its current form. I value the detail and scrutiny that has already been part of today's testimony, and I am principally concerned by the vague definitions and broad expansions of penalties included in this bill. Alarmingly, as of this testimony, the committee itself is clearly still figuring out which parts of this bill are amendments to versus consolidations of current law. Sections 1 to 23 were clarified as current law, but there are 47 sections of this bill. Our First Amendment rights are under attack nationally and locally. Without significant changes, I believe the proposed bill provides justification for increased police presence in marginalized communities, and I fear this bill could facilitate greater state-sponsored violence and repression of at-risk communities and activists across the state, while shielding police and government officials from accountability. The discrimination I have experienced as a queer Iranian American includes racist comments and harassment, Islamophobic threats, physical aggression, racial profiling, intimidation by law enforcement. Since October 7th, 2023, abuse has come almost exclusively from Zionists and from police. I have been yelled at and antagonized while walking around my city. I've been followed by cops. I've been shouted down and physically intimidated by Zionist counter-protesters at peaceful rallies advocating for the humanity of Palestinians. What section of this bill protects me from the police? What section of this bill protects me when Zionists scream anti-Semitism as soon as they are confronted with an alternate worldview? What part of this bill protects my friends from detainment and illegal deportation due to the expansion and abuse of the surveillance state? Hate crime laws were originally designed to protect historically marginalized communities. Expanding these protections to political ideology and occupation dilutes their purpose, undermining the intent behind civil rights protections. For example, the inclusion of religious objects in property protections loosely conflates common protest actions with hate crimes, a categorization that can and will be weaponized against activists. The language about masks and hoods is also a major concern which, although taken from prior law, I believe needs to be revised in light of our current context of dangerous right-wing censorship. Education is how we actually combat the roots of hate. I urge you to focus on investment in educational opportunities for all, investment in non-punitive, non-carceral processes for conflict resolution, investment in restorative justice. That is true investment in protecting all of our communities. I urge you to vote no on Governor Bill 6872 in its current form, and deeply consider these potential abuses in the amendment process going forward. Thanks for your time, patience, and consideration.
Thank you for your testimony. Questions, comments from committee members? Seeing none, thanks for being with us this afternoon. Appreciate it.
Appreciate it.
Next, we have Stacy Sobel.
Yep, Sobel. Good afternoon. Co-Chair Winfield, Co-Chair Staffstrom, and members of the committee.
I'm Stacy Sobel, Connecticut Regional Director of ADL, the Anti-Defamation League, and I'm pleased to be here today to testify on behalf of ADL regarding HB 6872, which would consolidate and revise Connecticut's hate crimes laws. As a member of the Governor's Hate Crimes Task Force, I was pleased to provide ADL's feedback to the task force on Connecticut's hate crime framework, and I'm honored to have the opportunity to share this with the committee. As you may know, ADL is a civil rights and anti-hate organization committed to combating anti-Semitism and all forms of bigotry. In 1981, ADL crafted the first model hate crimes law in the U.S. Today, 46 states and the District of Columbia have laws, many of which are based or similar to our model and have been unanimously upheld by the U.S. Supreme Court. ADL was also privileged to lead a broad coalition of civil rights, religious, educational, professional, law enforcement, and civic organizations for more than a decade in support of the 2009 Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act. Today, ADL continues to advocate for the passage of carefully crafted hate crimes laws across the country in coalition with other civil rights organizations and communities in a way that creates the center and centers the voices and concerns of those mostly directly impacted by hate-fueled violence. We appreciate this work to consolidate Connecticut's hate crimes laws, but we also see this current bill as an opportunity to not only consolidate the laws, but update them. In the time since these laws were passed, our understanding of how hate crimes manifest and how to best respond to and prevent them have evolved. Due to time limitations, ADL will submit more detailed recommendations in our written testimony. However, I would like to speak specifically about Section 14, which incorporates Connecticut's current law regarding concealing one's identity with a mask or a hood. ADL is currently working to revise or introduce masked harassment and intimidation laws across the country, and we believe this bill provides an opportunity to bring Connecticut's law in line with other states. We have unfortunately seen a resurgence in masked harassment with individuals across the ideological spectrum engaging in harassment and intimidation while wearing masks to conceal their identity. We appreciate that this bill allows Connecticut to revisit our own law, though we would recommend creating a separate offense of mass intimidation instead of tying the offense to hate crime statutes through protected identity characteristics. We can also strengthen the current law by prohibiting individuals from harassing or intimidating another person while wearing a mask for the primary purpose of concealing their identity, regardless of the target's identity. A statute prohibiting all masked harassment may be more effective to combat this tactic. ADL has model mask intimidation legislation, and we are happy to be a resource as this committee carefully considers this bill. Thank you so much for your consideration.
Thank you for your testimony, Ms. Sobel. Any questions from committee members? Seeing none, you are free to go. Thank you for being with us. Next up, we have Cheryl Sharp. Next up, we have Z. Rubin. Good afternoon. Thanks for waiting it out.
Can you hear me okay? My name is Z. Rubin. I'm here as an organizer of the Hartford Jewish Organizing Collective. I'm a proud queer Jew residing in Hartford. Regardless of my identity, I'm here to speak in opposition to the consolidation of hate crime statutes under Governor Bill 6872. I'll go quick on this. Section 5 should be amended to provide context as to what escalates the action of damaging, destroying, defacing a religious object or symbol to the level of a crime beyond the act of free expression. While burning of flags is protected speech under Texas v. Johnson and U.S. versus Eichmann, religious objects have not yet been adjudicated by the Supreme Court other than a 2003 ruling that permitted states to ban cross burnings, as we've already discussed. Failure to specify which objects and symbols are classified as religious leaves this section open to significant misinterpretation and subsequent abuse of law. Just as the CGS identifies and expands definitions of protected classes in this bill, similar care should be given to other considerations in these statutes. Secondly, Section 14 in its current form is antiquated in nature and leaves the opportunity for penalizing members of the public from taking actions to protect their physical health and the health of the people around them. Negligence to change this section of the bill may lead to abuse of said law in the current political climate. The legal ambiguity of the existing section in its current form does not include exceptions for medical masks, religious face coverings, or symbols of cultural expression related to one's national identity, such as the Palestinian keffiyeh, which the CEO of the ADL has likened to the swastika. In order to put this hate crime modification in the consolidated hate crime statutes, legislators must first analyze it through the lens of 2025 and observe how this section of the bill would be manipulated to target protesters exercising their First Amendment rights if, for example, they are wearing an N95 mask due to the presence of a large crowd. Many protesters acknowledge that wearing a mask helps prevent communicable diseases. While the initial statute may have been written to criminalize the KKK, it's crucial in a modern age to adapt the law so as to not unjustly upgrade acts of petty crime and civil disobedience into hate crime felonies. We must remember that police officers do not hold law degrees in most cases, and ambiguity to these laws lead to unjust arrests that upheave people's lives as their names are publicized through the news and they are saddled with damage to their public image. While I'm only able today to speak on two sections of this bill, I believe in order to ensure equitable justice, the entire bill must be more precisely and cautiously rewritten as to not endanger civil liberty. I understand the desire to simply pass the existing law and simultaneously classify certain actions as hate crimes to ensure Connecticut remains a safe space for marginalized people. However, it is crucial to consider the negative effects as a result of broad stroke actions. As lawmakers, you have the duty to shape our laws to work in favor of the people, not to their detriment. The law is a powerful tool that can oppress when it intends to protect. At surface level, this bill may appear to be common sense. However, it contains numerous lapses of judgment, vague language, and outright malignant choices that will have dire consequences of the civil liberties of the people of Connecticut. Thank you very much. Happy to answer any questions.
Thank you for your testimony. Questions, comments from committee members? Seeing none, thanks for being with us this afternoon.
Thank you. I'd also like to urge my wholehearted support for the bill that prohibits the use of AI.
Duly
for
noted.
Child pornography.
Thank you. Next up, we have Amber Kinney. Next up, we have Heather Summers.
Yes, good afternoon.
Good afternoon, Senator.
Hello, Chairman Winfield and Staffroom, ranking members Kissel and Fishbein. My name is Senator Heather Summers, representing the 18th District, and I am here to thank you for raising this bill. This is a bill that I had put in. It's Bill 1440. It's an act concerning the unauthorized use of disseminated or intimate, digitally altered or created through the use of artificial intelligence. And I think it's very important that we tackle this here. This came to me with someone in my district who had this happen to them. It is imperative for legislative action. The advancements in artificial intelligence have revolutionized various sectors, but oftentimes with these great leaps of technology comes a troubling application, which has emerged, which is the creation of non-consensual explicit content, commonly referred to as AI-generated or deepfake pornography. And it affects, in most of the time, 99% of the time, women. It's pervasive, harmful, and it violates consent and privacy in women. AI-generated porn often involves imposing an individual's face or likeness onto explicit content without their consent. Again, 99% of the victims are women here. Their psychological and social ramifications, victims of this non-consensual AI-generated porn, frequently endured significant trauma, anxiety, depression, and a pervasive sense of vulnerability. It has adverse effects on personal and professional relationships. And for an example, as a 15-year-old student from New Jersey became an advocate against AI misuse after falling victim herself, fighting the widespread nature of its use and issue. It also has a big erosion on the digital media, the loss of trust in digital media. The proliferation of deepfake technology undermines our trust in digital media, making it increasingly challenged distinguishing between what's authentic and what's fabricated content. I really believe that there needs to be a legislative response across all jurisdictions. I know that two other states have looked at this, California and Minnesota. Minnesota proposed legislation to improve civil penalties on companies that They called it nudification of AI technologies without consent, with fines reaching up to $500,000 each time. The United Kingdom passed an Online Safety Act to criminalize the sharing of intimate images that appear to depict another individual without their consent, encompassing deep fake images. And California also authorized the use for someone to be able to write to pursue legal action against the creators of this. It's imperative, I think, for a comprehensive legislative approach. And despite the efforts that many have made, I do believe that we need to criminalize the non-consensual content creation, that laws must explicitly criminalize the production of AI-generated explicit content without consent, ensuring that perpetrators face the appropriate legal actions and consequences. And I think the platforms have an accountability too. Social media platforms and websites should be mandated to implement swift removal processes for
Senator
non-essential.
Summers, I hate to interrupt you. We're at the 3-minute mark.
Okay, I'll summarize
just
really
open-
quick. Do you want me to
Yep,
summarize
Sure,
really quick?
sure, you can summarize.
Okay.
Yep, absolutely.
So I think platforms should be accountable and we need support for victims. And the unchecked proliferation of AI-generated porn poses a grave threat to individual privacy, mental well-being, and social trust, especially for women. And I hope you will seriously consider passing this into law. Thank you.
Thank you for your testimony, Senator Summers. Questions? Senator Kissel.
Thank you very much, Chairman Pacino. Senator Summers, thank you for being so patient and testifying this afternoon. I believe the state's attorney's office may have raised some concerns regarding constitutional rights of free speech regarding this proposal. I'm just wondering how you might respond to that.
Sure, I read their response, and I think we all have a constitutional right. I don't think you have a constitutional right to put my face on a pornographic image and put it up on the internet. And I think that's the difference. This is non-consensual, explicit images that someone is taking your likeness, your face, and putting it on somebody else's body, perhaps in a video doing something that is far from whatever you would ever do. I don't think we have a right to do that. You have a right to free speech, but I don't think that you have a right to do that. And especially to women and young girls that this is happening to, it is tragic and it destroys their lives. Once it's up on the social network, you can't get it back down. And so I think that there is a fine line there, and I don't agree with their assessment.
Thank you very much, Senator. Again, hope you feel better as time
Thank
marches
you.
on, and thank you very much, Mr. Chair.
Further questions, comments from committee members? Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Senator. Thank you for coming here today. This weekend I was listening to Ted Cruz's podcast, and he was talking about that federally they're working on this issue. Have you had the opportunity to look at the language that's being dealt with on a federal basis?
I have not, but I certainly could go look at that. I did not listen to Ted Cruz's podcast, or I have not been following it federally. I brought this to the legislation this year because this happened to a constituent of mine. And I will be quite honest with you. I have had constituents put my face on pictures that are very suggestive. They are things that I would, for example, never wear, never partake in, and texted them to me. They haven't put them up in social media, but even that I feel is inappropriate. I have made sure that I make that known, but they're doing this to me, and I'm an older woman. I can't imagine somebody doing this to a young 17-year-old girl and putting it up over the high school, having everybody see it. It's non-consensual, it's explicit, and it can destroy people's lives. And of course, 99% of the people or the victims of this are women. It's embarrassing, it's humbling, and right now there's no real recourse for them, but I will certainly take a look at that legislation. Thank you for bringing that to my attention.
No, I appreciate the exchange. He told a story about a young lady that was the victim of this and was threatened blackmail. Either you pay a certain amount of money or we're going to release this, and actually she ended up killing herself within an hour of hearing about this. And then her family was terrorized thereafter. They were threatened with the release of the then deceased young girl, and really a bad situation. In fact, I don't think that this language really goes far enough, because if we look at lines 24 through 25, it talks about the likeness of a person means an image that closely resembles a living identifiable person. But you could have let's say it's a high school situation, and there's one student in the high school that happens to like the Ottawa Senators, and the likeness doesn't necessarily look like them, but there's the Ottawa Senators badge on the individual that's doing it, that to the other students, they know this is the person that it's targeting, yet it doesn't resemble a living identifiable person. So, perhaps that can be considered. But I wanted to ask you, in this language, in line 30, there's the term visual perception. Do you know why that term? Because I just couldn't figure out why that was part of this. Is that the generation of the bad image, or is that what the person sees?
I believe that that is supposed to be what the person sees, the visual perception of it. And I can tell you the AI generated images that I have seen that were shown to me by this young girl that goes to one of our high schools. It was clear that it was her, but it had been, altered so that this particular girl had braces. They had taken the braces off, but you could tell it was her, but it had been doctored and touched up. I'll put that. And it was a heartbreaking situation for both herself, her family. They were a family that was very quiet, very, I'll say, religious. They are originally from a different country, so this just added another level of, shame to the family, so to speak. Horrific situation, non-consensual, going around a high school, destroying this young girl's lives, and in their mind, the family's reputation, with no recourse. And I, as Senator Kissel had mentioned, I do think we have the right to free speech, but nobody has the right to take a picture, especially of a minor, and alter it digitally and put it in an explicit and pornographic way and put it on the internet. And we have to do something to protect women, because this is only continuing and it's getting better and better. And, as I said, AI has great technology breakthroughs and some wonderful things that it can do. But there's also a dark side, and I would like us to pursue this, whether it's federally or here in the state of Connecticut, to protect women. When we do that, we reaffirm our commitment to protecting individuals from a digital exploitation and upholding the ethical standards of our society, and this should be one of them.
No, I agree, because at the end of the day, it's really not what a third person sees in the image. It's the individual that can say internally, they're looking to depict me.
Exactly.
So it appears the review here, the standard is the third party looking at the image if they can determine that it closely resembles a living identifiable person. But I think at the heart of this, we need to protect the individual. So, but thank you, Mr. Chairman.
And may I say, I agree with exactly what you said about the Ottawa Senators. That's a really good point. And I don't know how to write that into legislation, but if we could, if that could be included, I agree with you wholeheartedly on that point.
Thank you.
Further questions from committee members? Senator Summers, I just had one question for you. I know in your testimony you had mentioned civil penalties that were executed in Minnesota for businesses proliferating these images. Do you have any information on how much the penalties are and to what extent they're levied against businesses?
I have the information that it can reach up to $500,000. I can get you the information and send it to the committee, but it didn't say where they started, but basically up to $500,000 companies could be held accountable with fines reaching up to that.
Seeing no further questions, thank you for your testimony, Senator Summers. Get well
Thank you.
soon.
Next, we'll hear from Krista Estrada Perez. Krista Estrada Perez. Miles LaFemina.
Good afternoon. Can you all hear me?
Yes.
All right, fantastic. Good afternoon, Chairman Winfield, Chairman Safstrom, Vice Chairman Fazino, and members of the Judiciary Committee. My name is Miles LaFemina. I am a correction officer, husband, father, and son, and I am here to speak today in favor of Senate Bill 1443 regarding expanding the survivor's benefit and health insurance coverage to family members of correction officers and various investigators throughout the state killed in the line of duty. This bill seeks to extend the same benefit already afforded to police officers and firefighters, specifically with that $100,000 survivor's benefit to correction officers and investigators who also face significant danger every day on the job. While police officers and firefighters have long been recognized for the hazards they face, correction officers are often overlooked despite performing duties that are very similar and often equally perilous. Much like police officers, as a correction officer, we are exposed to daily risks in environments that are surrounded by violence. We work in high stress settings, often dealing with dangerous individuals who have little regard for authority. The statistics speaks for themselves. In fiscal year 2023, the Connecticut Department of Correction reported 214 staff assaults. In August of 2023, 2 correction officers were stabbed by an inmate at Garner Correctional Institute. Just recently, we had a female correction officer assaulted and choked by an inmate. In both instances, the staff were fortunate to survive, but it was only because responding officers were able to act quickly. A mere few seconds delay could have meant a life lost. These violent attacks are not specific to Connecticut. Across the nation, correction officers and staff are killed in the line of duty every year. Tragically, the life expectancy of a correction officer is just 58 years, far below the national average, about 20 years, due to the physical and psychological tolls of the job. While police officers and firefighters often receive a survivor's benefit in recognition of extreme hazards they face, correction officers, often the forgotten law enforcement officers, are not afforded the same protections. This bill would ensure that correction officers and investigators who face similar risks receive the same support. This legislation is the least we can do for those who work in dangerous, often thankless roles. It is acknowledgement of the critical work they do and the sacrifices they make for the safety of our communities. Senate Bill 1443 would provide vital peace of mind for correction officers, the investigators, and their families, knowing that in the unfortunate event of a tragedy, they will not be left behind. I would also like to make a recommendation to the committee, if they could, include all correctional employees. So it'll also include the counselors, maintenance staff, medical staff, teachers, supervisors, etc., that work in the same environment. I urge you to support this important bill, ensuring that those who risk their lives every day for public safety are not forgotten and that their families are protected if the unthinkable occurs. Thank you for your time, attention, and consideration in this very critical matter.
Thank you. Comment or question from members of the committee? Representative Safstrom.
Thank you, Mr. Chair, and Miles, thank you for being with us today and for your advocacy on this. Just a quick question. So my understanding was part of the reason the police and fire bill was passed, I guess, a year or two ago, was because there wasn't necessarily a death benefit in every municipality's sort of collective bargaining agreement. Do you know, sort of under the current state collective bargaining, whether there's any sort of death benefit built into the state CBAC agreements?
Not to my knowledge. I mean, I sit on the executive board for Local 1565, which is part of AFSCME NP4. And to my knowledge, we have zero death benefit in there, other than I believe it's I could be mistaken, but last I knew it was right around like a half a year salary or something like that, but I could be mistaken. I don't have it right in front of me.
Okay.
And I believe that's actually a direct benefit from the union itself.
Okay, not out of the state CBAC agreement. Okay.
Yeah. And I mean, not for nothing, with this entire thing, this really shouldn't affect the bottom line, if you will. This happens very rarely. Since I've been here, I cannot think of a line of duty death that we've had in the Department of Correction. However,
But
if the unthinkable happens and occurs, it would be an extra level of protection for a loved one.
understood and agreed. Thank you.
Thank you. Senator Kissel.
Thank you very much, Chairman Winfield. I just want to say thank you for coming to testify. As the senator from North Central Connecticut, I have more correctional facilities in my district now than any other state senator. I have Local 391, and I very much appreciate your testimony on behalf of the men and women that work in the Department of Corrections. Thank you, Mr. Chair.
Thank you.
Thank you, sir.
Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us today. Okay.
Have a great day, everyone.
You too. Next, we have Nathan Schaffner.
Good afternoon, members of the committee. I'm attorney Nathan Schaffner. I'm a workers' comp attorney in Norwich. I've been practicing for 36 years. I'm here testifying on behalf of House Bill 7141, specifically Section 1, that would deal with an increase of permanent partial disability benefits for the cervical. Last year, this bill was presented. I also testified, and I'm happy to testify some more about this. What we need to understand about neck claims that are unique to most of the other body parts is that there's a lot of medical treatment that's done with the neck claim to determine where the problems are coming from. Oftentimes, they could be emanating from the shoulder. Oftentimes, the neck radiates up into the head. And while there's extensive medical observation on that, I would say that the rate of injuries to the neck is very low, at least in my experience it is. That said, the neck does have a debilitating aspect to an injured worker. And in the scheme of workers' compensation, permanent partial disability is paid at pretty much the end of the case. And oftentimes it happens that while it's contemplated that one's receipt of an impairment rating can happen while they're working, oftentimes that's not the case, in which case they're still looking for work, or maybe they've successfully enrolled in a retraining program. And once they start receiving the impairment rating, it's for a limited number of weeks. There's a misunderstanding that because the current statute's at 117, or it may go up to 208, they're going to get 117 weeks or 208 weeks of benefits, and that's not the case. They're going to be getting a percentage of that benefit. So if it was increased to 208, they would be looking at 20.8 weeks of benefits. Average retraining program is 6 months to upwards to 18 months. And oftentimes people find that they would run out of benefits while in the retraining aspect of this. It's not a lot to ask for an increase of this impairment rating. Many people believe the neck should be the same value as the back, which is 374 weeks. And in my written statement, I point out that the neck is less than a foot, it's less than the hands, it's obviously less than the arms, and it's certainly less than the back. And it was about a year ago, there was a working committee, and I was proud to be a member of that. And the consensus of the group is that the rating had to be increased, and it was proposed that we raise it to 208 weeks to be more akin with the arm claim. So in spirit of this legislative body, that for the last few years, I'll conclude, the last few years, you've found ways to tinker with the act to improve the lives of injured workers, and we think this would support that. So thank you very much, and happy to answer any questions anyone might have.
Thank you. Comments, questions from members of the committee? Comment, question from members of the committee? Representative Quinn.
Nate, thank you for being here. And again, thank you for your service to our working group. I agree on how we came out with this compromise. And I'm sure you've seen it in your practice where there's an upper shoulder into the neck claim and the doctor isn't going to rate both parts. So you're kind of hoping that he rates the shoulder because it's worth more than the neck. I mean, I know I've seen that. I don't know about you.
Oh, I've seen that, and I've seen it the other way. I've seen practitioners where you have a neck injury, try to get ratings because there are things called serogenic headaches that people get, and they get treatment for it. And they've tried to get ratings for the head because the head has a rating of 500 and it's based on a percentage of 520. So if they could get a 5% for that, that would be an additional 26 weeks. I've seen the same way where they've tried to get additional ratings because of the radiating pain from the neck down there. And doctors, for the most part, don't do that. They won't provide a rating to an adjacent body part unless there's really a surgical necessity to it. So again, it makes more sense to increase the rating for the neck. It's not a big thing. In my written remarks, I've tried to find specific information as to Connecticut. I did an extrapolation. I don't think the cost is very, very large. Certainly not what the fiscal note suggested last year, in my opinion.
Yeah, I'm still not sure how that was calculated because we had about a 30 to 40% increase in the total number of weeks, yet they did 100% increase in what they thought it was going to cost, which
Again, I don't know how they did that. I've seen in the past some analysis on fiscal notes with workers' compensation, and they usually base it on the max rates, which not everyone's at the max rate. I'd say very, very few people meet that. And the other thing is I think they look at the maximum amount. So they'll see the 117 times the max rate, and boom, you're up to $1 million a year. I don't think it's that much. I don't even think it's about 1/10 of it, in my opinion. And again, my written remarks reflect that.
great. Thank you. I don't have any other questions.
Thank you, Representative. Comment or question from other members of the committee? Comment or question from other members of the committee? If not, Attorney Schaffner, thank you for joining us again.
Thank you very much.
Next, we have Bulaong Ramiz.
Hi, can you all hear me okay?
Yes, we can.
Okay, wonderful. Good afternoon, Senator Winfield, Reps Staffstrom, apologies, and committee members. My name is Dr. Bulaong Ramiz. I'm an educator, consultant, and equity practitioner who has spent the past decade working with communities across Connecticut to advance understandings of identity, bias, equity, and social justice. I am here in opposition to House Bill 6872, the consolidation bill of hate crimes. I do appreciate consolidating hate crimes. I do have a couple of concerns I'd like to raise. This bill proposes eliminating the requirement that a defendant acted, quote unquote, maliciously, citing prosecutorial challenges in proving intent. This change could lead to individuals being charged with felonies for actions that may have been rooted in ignorance over hate. As a Black American whose family has endured white supremacist violence, I understand the intent and can appreciate the spirit behind this provision. However, as an educator, I have seen firsthand how many young people in our state cause harm due to lack of education, not malice. Increasing criminal penalties without investing in our education will only fuel further resentment and unexamined bias, particularly among those who have not had opportunities to learn about the diverse identities and histories of marginalized communities within our state. The bill proposes making it a Class D felony to commit a hate crime while wearing a mask or hood. And once again, while I understand the historical context, having had my own family fleeing the KKK terror in Georgia in the 1940s to come here to the state of Connecticut, I also recognize the dangers of such vague language. We are living through a global pandemic. Mask wearing remains necessary for public health reasons, especially as new diseases continue to emerge and citizens remain underinsured. Additionally, marginalized communities often rely on anonymity to safely engage in protests and political dissent due to the bias and disproportionality of punishment by law enforcement and the legal system, including the ongoing doxing and targeting we are seeing of pro-Palestinian activists, scholars, and students. This provision does little to address actual hate crimes, but creates another legal tool that could be weaponized against those seeking justice. Lastly, I'd like to just name this whole country was founded by an act of hate. Our country's original sin, the murder and displacement of Indigenous people, and the enslavement of Black Africans. Call me optimistic or naive, but I'd like to live in a state being governed by leaders who are willing to engage in more truth-telling and repair, and not further push forward policies and laws that threaten the freedoms of people daring to resist the eradication of another people funded by our tax dollars. HB 6872, as written, will increase the overcriminalizing of people who need education, not incarceration, and will restrict the rights of those engaging in legitimate protests and health-conscious safety. I urge you to vote no, send this bill back for necessary revisions, and I urge our Democratic leaders to get honest about if they're willing to commit to all of Connecticut's residents, or continue to move in step with the fascist regime we are seeing at the White House. And it may be elitist to stay, but I am from the great state of Connecticut, so I would hope that we are much better than that. I also want to make a name that I don't know what technology exists on the back end, but we really need closed captioning for these hearings for people who want to fully participate and might not be able to hear speakers. So
Yes,
thank you.
Dr. Mays, thank you. Let me see. Are there comments or questions for the individual testifying in front of us? Are there comments or questions? Seeing none, thank you very much for joining us. And I saw that you were in the room earlier, so thank you for having joined us in person. Next, we have Richard Wilson.
Hello, everybody. I admire your stamina. Been here with you all day. Chair Staffstrom, Chair Winfield, ranking members Kissel and Fishbein, members of the Judiciary Committee, thank you very much for the opportunity to speak to you today in support of HB 6872, an act revising and consolidating the hate crime statutes. I'm Richard Wilson, professor at University of Connecticut School of Law for the last 22 years and a member of the Hate Crimes Advisory Council. I co-chair the Subcommittee on Law Enforcement, Reporting, and Data Analysis, which this year launched reporthatect.gov, a public portal to report hate crimes. And last year, we worked with Post Council to create a statewide hate crime reporting form for law enforcement, the first such statewide hate crime checklist for police in the country. There's much that we have in Connecticut to be proud of in our willingness to combat hate crimes. Now, just a little bit of history. The need to revise the hate crime statutes became apparent as soon as the Hate Crime Advisory Council, which is made up of a variety of community organizations and ex officio members, chief state's attorney, chief public defender, variety of groups, when we were formed and began our work in 2021. The judicial branch statistics we received early on showed that hate crimes are underreported by victims, undercharged by police, and often do not lead to conviction. The council investigated why our system for protecting Connecticut citizens from hate crimes was not functioning as intended. Police told us the statutes were scattered around the penal code, hard to find. They were also hard to understand, and this made training difficult. Prosecutors and criminal defense attorneys told us that the language of the statutes made them difficult to interpret and apply. We heard the words unworkable frequently. My colleague, Professor Pandya, has already explained the benefits of consolidating the statutes and ensuring consistency in the protected groups. Yet there is a glaring gap in Connecticut statutes. Hate crimes in Connecticut are largely GA crimes, misdemeanors, lower level felonies. They do not cover very serious Class A and B crimes such as murder and arson, leaving Connecticut citizens unprotected by the law. If, God forbid, there were a mass shooting in Connecticut, like there was in 2022 at the Top Supermarket in Buffalo, or the 2018 Tree of Life synagogue shooting in Pittsburgh, state law enforcement would not be able to charge and prosecute the mass killings as hate crimes. Victims from mass shootings in other states reporting feeling re-traumatized in cases where the shooter is motivated by hate, but a hate crime is not charged. I believe the moment is now to address this. I don't think it's time to kick this issue down the road. I urge you to address this issue in this session. Thank you.
Thank you. Comment or question from members of the committee? Comment or question? Seeing none, thank you very much for joining us today.
Thank you.
That brings me to the end of my list. And I don't believe anyone who signed up is in the room. So with that, I think we are going to call this hearing to a close, and we will rejoin you on Wednesday for another one of our lovely hearings.